Good. Well, I'll call the meeting to order. Jake Evans, Chairman of the Commission. I appreciate everyone coming. This will be our third meeting of the year. We've consolidated a number of the meetings in a short period because we were delayed 6 months, but that's okay. I want to welcome Miss Haley Brown, who's with us here, and she was hired a couple weeks ago. So welcome. We look forward to your contribution to the commission. So first, is there any amendments that we made to the
Mr. Chairman, under preliminary hearings, section 4, position A, in the matter of Keisha Lance Bottoms, I'm gonna ask that a motion be made to agree to continue this case. But I'm also gonna ask that a motion be made, especially setting this case for our next commission meeting. I'm doing that, and why I think this is necessary. This case was.
Let's go first. We'll just focus on the agenda, and then we can get to that whenever it comes.
Okay.
So, is there any other amendments that we need to make to the agenda? Or is that it? Any of the preliminary hearings we've moved up to a consent order?
Mr. Lane, do we have any of those that moved up at the last minute? I think we may have had a couple.
We do. If you would like, we can take them in their order during the preliminary hearings if you don't have to move them. But I can tell you, he needs to move them, you don't move them.
That works. Let's do the former. Let's leave them where they're at if we can just handle it that way.
Because they come after the only testimony, so
Okay.
it's not here, just adjust.
That's fine. All right. Anything else on the agenda? Are we good otherwise?
We'll do it otherwise.
Okay. So review and approval of meeting minutes for the regular meeting, which was on August 6, 2020. Did the commissioners all have an opportunity to review those? And if so, any revisions or adjustments that are needed? All right, hearing none, I'll make a motion that we approve the meeting minutes for the regular meeting for August 6, 2020, if I can get a second. Second. All right, we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. All opposed? All right, the motion carries 5-0, and the meeting minutes for August 6, 2020 have been adopted. Okay, so we'll jump into consent orders, and it looks like the first one is in the matter of Mr. Colton Moore, and Secretary Marty, you've got that one, so whenever you're ready, we're ready.
Thank you, Mr. Chairman. This matter, Mr. Moore is a state representative out of Trenton. Mr. Moore's case originated during the legislative audit we conducted of the House and Senate members last year. There were some delays due to some campaigning issues and legislative leave he had, but ultimately during that audit it was discovered that Mr. Moore, in his January 31, 2019 filing, clicked that box that said zeros all the way down, that he had no cash on hand, no contributions to report, no expenditures, and nothing to carry over, which we knew was inaccurate based on his previous filings. Ultimately, we issued subpoenas and looked at bank records. Mr. Moore had a little under $3,000 in contributions on that January 31, 2019 CCDR that were not reported. He had a little under $3,000 as well as in expenditures that were not reported. And he had two other contributions he failed to report. He filed those respective reports, and there was contributions and expenditures there. It looked like he just missed a contribution in October and December. But that was the extent of the failure to file. Mr. Moore has agreed to pay a fine in the amount of $2,500. This is within the typical or appropriate range of a fine for this. Some factors that went into determining this figure: Mr. Moore, in mitigation, is a first-time candidate. In aggravation, he admitted intentionally filing that. So initially, this was going to be a slightly higher fine. Ultimately, another mitigating factor is Mr. Moore, as a state representative, ran for a state Senate seat. And because of the coronavirus pandemic and because of the AO we passed, he was not able to campaign. He's not able to campaign and raise money. So he was only able to campaign out of pocket, and he lost, I looked at the record, somewhere around $33,000 in personal assets that he'll never be able to recoup because he lost the election. So we bumped it back down to the $2,500 that we were initially at, and he agreed to pay that fine.
Okay. My favorite question. Was Mr. Moore served?
Mr. Moore has been served a number of times. Mr. Moore is looking forward to this being over.
Okay. And it looks like he signed this. Was he represented by counsel?
He was not. He represented himself.
All right. The commissioners have any questions? Okay. Hearing none, and in light of the fact that he has consented to it, he has signed it, had the opportunity to have counsel, and it's a consent order, I will move that we adopt the proposed consent order in the matter of Colton Moore.
Second.
Okay, we've got a motion, we've got a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay, motion carries 5-0. And next we've got in the matter of Normarie Merritt. Mr. Lane, whenever you're ready.
Thank you, Mr. Chairman. Commissioners, before you, you have case number 2012-0013 in the matter of Ms. Normarie Merritt. This case began in March 29, 2012, and a third-party complaint was filed by Mr. Robert H. Davis. Ms. Merritt was at that time a candidate for Cobb County Superior Court. Mr. Davis alleged a number of violations centering upon Mrs. Merritt's failure to file a number of campaign contribution disclosure reports. The Commission found probable cause that the Campaign Finance Act had been violated on September 19, 2016. The case was referred to the Attorney General's office for further prosecution. Mr. Fuller took it from there. He concluded negotiations with Ms. Merritt, and everyone came to an agreement that the only report that remained outstanding once we pulled apart her 3 separate campaign filing accounts was a December 31st, 2010 campaign contribution disclosure report. That information has been filed. She has agreed to the payment of $125 civil penalty. The parties agree, and we ask that you adopt the consent order as presented.
Okay, and Ms. Merritt was served and she signed this.
And she's happy.
And is she here today?
No, sir.
Okay. Commissioners, any questions? Go ahead, Mr. Commissioner Wise.
It says that respondent here failed to file a December 31st, 2010 CCDR.
Yes, sir.
And when was the complaint filed?
The complaint was filed in 2012, March 29th, 2012.
So for a failure to file, isn't it true that the complaint would need to be filed within a year?
That is an affirmative defense that was not raised. So it is right. But you are correct.
And where are you getting the affirmative defense piece of that from?
It's based on our standing practices and procedures, and no one has raised it.
Was the respondent represented by counsel?
Not to my knowledge. I believe she is a member of the law. She'd have to be if she's running a superior court case. Sorry. I don't think, I'm going to rephrase that. She is a member of the law.
Okay.
All right, any other questions? All right, hearing none, I will move that we adopt the proposed consent order in the matter of Normarie Merritt. All right, we have a motion, a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Was that a 5-0? Commissioner, why don't you vote? Okay. So that motion carried 5-0. Okay, next up, I will call the matter E. Neal Jump. Mr. Cusack, it looks like that's you, so go ahead.
That's correct. And this is the matter of E. Neal Jump. This is case number 20-0006-C. This stems from a third-party complaint filed by Heather Butler on February 6th of 2020. Mr. Jump is the current sheriff in Lynn County and has served 2 terms in that capacity since 2012. This complaint stems from a CCDR that he filed, in which it was June 30th, 2019 CCDR. There was a timely filed CCDR in this case, and what happened, it listed some of the...
Hold on a second, Mr. Cusack, and all of our participants on Zoom, please make sure that you mute your line so that we don't have any background or feedback here in the meeting. Thank you. Go ahead.
And so this stemmed from the June 30th CCDR.
Hold up. Where's Robert? Jeff, can you grab Erwin to mute him? Erwin, can you mute that iPhone?
That one should have disappeared. He said, yeah.
Are they muted or?
Yes, sir.
Okay, they're back. We just need to mute them.
Okay, go ahead, Mr. Cusack.
All right, in this case, in the June 30th, 2019 CCDR, it was timely filed. In that filing, the face sheet listed the contributions and expenditures for the campaign. It listed some of the contributors, but not all of them. It listed all the expenditures, but some of the contributors were missing because the math didn't add up. So there was a complaint filed by Ms. Butler. Specifically, there was 3 contributions that were missing from William Legan, Jeffrey Jones, and Georgia Pack. The Jump campaign, upon receiving this complaint, went back, filed those contributions in there that were left out. It's my understanding it was a paperwork mistake in that there were some of the contributions were actually filed, and then for some reason this page that held these contributions was just not filed. Now, whether that was forgot or whether it was an intentional mistake, it doesn't really matter. But those 3 contributions were left out. But it was accounted for on the face sheet of the total contributions. So they agreed to a $150 fine. They immediately rectified this mistake, amended this filing, brought the math into compliance. So that's why they agreed to the $150 fine. So I'd ask the commission to adopt this consent hearing.
Okay. And so he signed it and he's received notice.
Yes, he did not make the trip from Flint County.
Okay. Any other questions by the commissioners? All right, hearing none, I'll move that we adopt the proposed consent order in the matter of E. Neal Jump. We got a motion and a second. Any discussion? Hearing none, I will call the question. All in favor, say aye. Aye. All opposed? All right, the motion carries 5-0. And next we've got, I will call in the matter of Deborah Gonzalez and Mr. Cusack. It looks like that's you as well.
It is. This is case number 2018-0054 in the matter of Deborah Gonzalez. This stems from a third-party complaint that was filed on June 5th of 2018. Ms. Gonzalez was the successful candidate in the House of Representatives District 117 special election, which was held on November 7th of 2017. That's the Athens area. She filed her DOI on May 12th of 2017 and qualified on September 15th of 2018. At the time of this violation, she had to, she filed for one CCDR. She had one CCDR that was due prior to this special election, 15 days prior. She filed that on time. In the time in between that election, or that filing and the election, she had filed what's called a 2-day report. She was a first-time candidate for a 2-day business report in which she had to disclose any contribution over $1,000 in that time via that 2-day business report. When she filed her end of the year, December 31st CCDR, there was a complaint filed that she had taken 2 contributions for $1,000 on October 24th of 2017 and $2,600 on October 26th of 2017 prior to the election. that were not disclosed in that relevant time period of the 2-day business report. Upon receiving this complaint, she she filed those 2-day business reports, being that she was a first-time candidate and did not file this. That's why this is being treated as a compliance order rather than a fine, because those were actually disclosed on that December 31st report. So there was no intent to hide contributions, but given that she was a first-time candidate, we're treating this as a compliance order rather than a monetary fine. So that's the reason for this compliance order.
So she initially did not disclose them, but ultimately did disclose them?
She disclosed them on the December 31st report. So there's that time period in between where she had to file, I believe, on October 23rd, 2017. Now these contributions happened after that report. The one CCDR prior to the election was due. So she had to file a 2-day business report in that time period and didn't. But she disclosed it on the December 31st CCDR, which would have been the next filing in which those were due.
Okay. Is there anyone here on behalf of any of these consent orders? Just so I make sure I don't miss anybody from complaining.
We had sent Ms. Gonzalez the Zoom link, but I don't see her in the lobby for the Zoom. She was a maybe. Yeah.
Okay. I just want to make sure that we give everyone an opportunity to speak if they're here to speak for any of these. So. Okay. Hey, Commissioners, any questions on Ms. Gonzalez? Mr. Cranville, Commissioner Cranville?
I just noted that this agreement was from December of 2019. What was the delay there?
It was just a matter of getting it on the calendar. I had other cases that we had consent orders, so this was just sort of fell down the totem pole.
Okay. Any other questions? Hearing none, I will make the motion that we adopt the proposed consent order in the matter of Deborah Gonzalez.
Second.
We have a motion and a second. Any discussion? Hearing none, I will call the question. All in favor say aye. Aye. All opposed? Okay. Motion carries 5-0. And then next we've got in the matter of Shirley Ritchie, Mr. Cusack, please proceed.
Yes, this one's in the matter of Shirley Ritchie. This is case 20-0019-C. This came about via a third-party complaint that was filed on May 5th of 2020. Ms. Ritchie was the unsuccessful candidate in the Georgia House of Representatives District 46 Democratic primary, which was held on June 9th of 2020. She filed her DOI on March 9th of 2020 and qualified on March 2nd, 2020. She was another first-time candidate running for office. This complaint came in and alleged that Ms. Ritchie had taken contributions without reporting them. Specifically, there was a screenshot from Facebook in which someone said that they had just gave to her campaign. In reviewing this complaint and talking to Ms. Ritchie, she was able to show, or she went back and amended her filings, and she took in a grand total of $461 during the pendency of her campaign. 400 of that came in a loan for herself so that she may pay her qualifying fee. There was $61 that was taken in small dollar donations that just wasn't disclosed. In this case, it was a $10 contribution that was given from her niece. So she went back and amended those filings to include that $61 that she raised, in which she didn't actually have to disclose it. She just disclosed it in the face sheet under the contributions under $100. She's a first-time candidate. Given the amount of money that was taken in this case, or the amount of contributions, the $61, I believe the compliance order was appropriate in this case. This wasn't a high dollar campaign. Given just sort of the proportionality of a punishment in this, I believe a compliance order is appropriate just due to the dollar amount. It was a $10 contribution, so to fine her $10 seems a little petty. So that's why it's we're taking this up as a compliance order.
Okay. Any questions from the commissioners? All right, I will move that we adopt the proposed consent order in the matter of Shirley Ritchie. We got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay, motion carries 5-0. Next, we've got in the matter of Eric E. Allen. Mr. Cusack?
Yes, this is in the matter of Eric Eugene Allen. This is case number 20-005-C. This came about by a third-party complaint which was filed on July 10th of 2020. Mr. Allen is the current House of Representatives member for District 40 and serves in the General Assembly. He filed his declaration of intent to accept campaign contributions on January 13th, 2017, and qualified to serve a second term in the House on March 2nd of 2020. The third-party complaint came in and alleged that he actually took contributions during the legislative session. Mr. Allen reached out to our office, was able to provide proof that his website, he turns off the ability to take money during session, which most of our legislators do. What didn't happen was there was somebody who gave recurring donations in which you can set up every month. You can give a predetermined amount, $25, $30, $100. So that function, for whatever reason, did not register when he turned off this ability to accept money during the session. Now, when he filed his CCDR, he realized that they had accidentally taken money during the session via these recurring payments. So they immediately refunded those, and there was one refund that didn't show up on a CCDR, and that was for $100. And that refund wasn't, he actually provided proof that they had refunded the money, but never put it on the CCDR. So in reality, he had refunded the money that had been taken during session, and they figured out the issue with the website so that they won't take recurring payments anymore, or can at least shut off the recurring payments function during the legislative session. So in this case, it's being treated as a compliance order because he did comply in refunding the amount of money that was taken during session, and he did that prior to the complaint. So that's why this is a compliance order with the understanding, hey, don't do this again. Make sure that these functions are turned off during the legislative session. So that's why this is a compliance order as opposed to any fine being levied in this case.
Okay. Commissioner Watts, any questions?
Yes, Mr. Cusack, did you prepare this compliance order?
I believe I prepared most of it. Some of it was tweaked, I believe, by Mr. Allen himself.
Okay. There's a sentence in the second paragraph under findings of fact that says, the 2020 Georgia General Assembly was in session from January 13th, 2020 until June 15th, 2020. And during this time, the members were barred from accepting campaign contributions. You see that?
Yes.
What is the basis for the use of the word until?
I guess that would just mean that the session went from January 13th until June 15th of 2020.
There's no adjournment in between?
Depends on depends on who you're asking.
Okay. Secretary Monty?
I'm confirming something. I would make a motion because in jest, Mr. Commissioner Watts pointed this out, but in true legislative, sine die adjourned June 26th. So that's a scrivener's error. It shouldn't be the 15th or the 26th. So whoever makes the motion to accept it, if that does happen, I should make that amendment.
Okay. Commissioners, any other comments or questions? All right, I will make the motion that we adopt this proposed consent order in the matter of Eric E. Allen with the amendment to the consent order that session adjourned on what day?
26th.
June 26th, 2020. Okay, we got a motion and a second. Any discussion? Commissioner Crandall?
I guess my only question is, I mean, if you amend this, do we have to go get Mr. Allen or we just have to sign it?
Mr. Cusack?
I believe we would, but I think when this consent order was sent out, we might have still been in the legislative session and we didn't get it back until then, so it might have been an ongoing thing, but I believe we can still accept it as is. Just
Yeah, it's not a material change.
correct.
Well, I'd say we keep the amendment and they could, I presume he will have to re-execute, but I don't see, subject to his re-execution agreement, I think that we're gonna adopt this.
So, Mr. Chairman, perhaps the motion should be amended to state subject to Mr. Allen's acceptance of the change in language. This commission will adopt the consent order.
Okay, I'm good with that. I'll second that amendment. So I'll restate the motion and then we will have a clean vote. And the motion is the commission moves to adopt the proposed consent order in the matter of Eric E. Allen, subject to Mr. Allen's consent to the change in language of session ending on June 26, 2020. Okay, we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 5-0. Last but not least, on consent order, Mr. Cusack, in the matter of committee opposing consolidation.
Yes, this is in the matter of committee opposing consolidation. This is case number 2015-0058. This was a third-party complaint that was filed on October 13th of 2015. Just a little background, there was a ballot question in Milledgeville of whether the Milledgeville and Baldwin County government should consolidate. And I guess both these groups hated each other because they both filed complaints on each other, alleging the same thing, that on both of their signs that they both did not put the chairperson of their campaign or the ballot committee on those signs. There's a special provision in the rule when it comes to ballot committees. It said that you must put the committee or the ballot committee that's sponsoring this or paying for the sign, but also the chairperson of that campaign. So neither of these committees did that. So we're handling committee opposing consolidation first. I'm working on the committee that was for consolidation. That should be coming on in December, but both of them filed the same complaints against each other. That's basically all that occurred in this matter. They both did not seem to reach that $500 threshold to file. So in the signs that they made, they left off the chairperson. That's why this is being treated as a compliance order. This is sort of one of a ticky-tack rule in which it just seems like they're harassing each other by filing this complaint. So this is how I'm choosing to take this up with no fine, because they put who the sign was funded by. They just didn't put the chairperson.
Okay. Comments or questions? Commissioner Watts?
One question, Mr. Cusack, this one's not signed. Is there a signed version of this?
Yes, it was signed, I think 2 days ago or either yesterday, and emailed back to me. So that's why there isn't a signed one y'all have. So it was just recently agreed to. I was able to get Mr. Barnes, the chairperson, on the phone. It took me a little bit.
No worries, thanks.
Okay. I will just note a lot of compliance orders here, which I'm okay with. I defer to you guys' discretion over what we need to do to ensure that we are taken seriously and ensure that the laws of Georgia on campaign finance are taken seriously, and to ensure that the people of Georgia know that these rules are being complied with. But I do want to note that we want bite and we want to be taken seriously, and so just consider that as we go forward. A lot of these are not severe infractions, and I acknowledge that fact. But I just want that consideration to be taken into whenever we're making these compliance and consent orders.
And Mr. Chair, some of these complaints we're getting, especially it being election year, are sort of petty on these rules. So unfortunately, they are violations, but in the scheme of our violations, they're on the low end of what's happening. So that's why some of these are being taken as compliance orders.
Now, I understand. Okay. Any other questions, comments? All right, hearing none, I'll move that we adopt the proposed compliance order in the matter of committee opposing consolidation. All right, we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 5-0. So next we'll go to the preliminary hearings, and do we have that is attending in person and virtually for these? Because I think we should give those preference to the extent that we have people. Just B? Okay. Let's go ahead and call that one first then. And so I'll call it in the matter of Sept K. Baker. And do we have someone attending virtually on behalf of Mr. Baker?
I believe you have Mr. Mark Shelnut, who is Mr. Baker's attorney. You have Mr. Baker, I believe, and then Mr. Vincent Watkins.
Okay.
If there's anyone else, I'm not aware of.
And who is representing Mr. Baker?
Mr. Mark Shelnut.
Shelnut. Mr. Shelnut, are you there? Can you hear us, Mr. Shelnut? We may have to unmute him.
Fortunately, my controls are covered up by the toolbar. Give me just a moment. I got it.
So, Mr. Shelnut, we can't hear you,
He's still muted, and I don't.
and we're trying to figure out how to unmute you, so bear with us for a second.
He has to unmute himself.
Okay, he's unmuted himself.
Mr. Shelnut, can you speak? So have we unmuted Mr. Shelnut?
Mr. Shelnut is unmuted.
So Mr. Shelnut, if you could give us a thumbs up if you can hear us. So I don't know if he can hear us.
His client, Mr. Baker, is also unmuted.
Can we send him a message, or what would you guys recommend on getting him unmuted and able to engage?
If you will permit me, I will get his phone number, and if you'd like to take.
Okay, we'll take a 5-minute recess.
Period. I think those are inherently inconsistent. If we're going to continue it to December 10th, then let's continue it to December 10th. Have it set. Have the staff inform council for the Bottoms campaign that it's set for December 10th. And that if there are going to be any requests for continuances, given what is the discussion today, that there needs to be a formal request made in some type of procedure that is appropriate for this tribunal, or we're going to go forward on the 10th. I mean, let's just continue until the 10th. I don't know what a special order would say other than what we've articulated today.
Okay, Commissioner Thompson, you have any thoughts? You've been quiet over there today.
No, sir.
Okay. He's the smartest man in the room. All right, Commissioner Watts.
Yeah, so I think I'm largely in agreement with what Commissioner Barnum just said. I just want to put it on the record that if there's an objection to moving or setting the calendar, or in this case for the calendar on December 10th, whether it's from the staff or the Bottoms campaign, all the parties can discuss among themselves whatever they want to discuss, but there has to be a motion in front of the commission for us to act. I think, again, going back to the leave of absence, that's just an inappropriate vehicle. It's a nice notice. It's an inappropriate vehicle for which we're going to act. Now, today, we're acting sua sponte, if you will, okay? Because we have this notice in front of us. And to the staff's point, they want no procedural defects here, which I appreciate. But I would just request that if there are issues like this in the future, particularly with scheduling, that the staff or the respondent, whoever it may be, brings a formal motion before the commission for which we can act on.
All right, Commissioner Cranfield.
Sorry, now I'm back. And I think that's why I think an order may be appropriate here, is that I think the information has to be conveyed that, look, the way that you did it previous, because no one is here. Well, we don't know if they're going to actually, watch the tape of this or anything, but they don't know that the vehicle that they tried to use last time was the inappropriate way to do it. We don't want to end up in the same situation where we just have a notice of leave of absence. I think that, and I don't know what's in this order that's been drafted, but I think it would be useful to say in the order that we received your notice of leave of absence. What we need is a motion for continuance. Nevertheless, in this in the understanding of what you requested, we went ahead and continued the case, but it's going to be continued to December 10th. And if you have any problems with that date, we need to have a motion.
Do we have that order?
We would need
What's important to remember here is getting this case moved forward and getting it before the commission. I know it's been pending for a little while, and I've sensed frustration as far as communication with the Bottoms campaign. However, we also have an obligation to work within the limitations of opposing counsel and the other party. So it comes down to, do we need an order, especially setting this for December? And I'll let you provide the response to this, Secretary. Does continuing the case, is that sufficient order provided?
articulated the order we need. That puts them on legal notice immediately that their mechanism for continuing the case is inappropriate. Explain that if they have an objection, this is how you do it. Otherwise, it is docketed for this date in December.
Okay. Commissioners, any thoughts?
I don't have a problem with that. I mean, whatnot. So an order is fine. Continue it to a different date besides December 10th.
In the case of Keisha Lance Bottoms, 20180059, that this matter be continued to our regularly scheduled meeting on December 10th, 2020. That notice of said continuance be communicated to the Bottoms campaign and to counsel for the Bottoms campaign. Further move that in that notice, counsel for the Bottoms campaign be specifically informed that should there be any requests for further continuance, or should they not be available for that meeting, that a proper request for continuance be submitted to this body in compliance with the rules of this body. This notice is not put forth for this body, that the commission reserves the right to go forward on December 10th without counsel or without the Bottoms campaign. I further move that in the notice to the Bottoms campaign, that a contact name, phone number, and email for the staff be provided so that anyone on behalf of the Bottoms can be in contact with the staff to discuss the proposed December 10th meeting.
Okay, we've got a pending motion. Do we have a second?
I'll second that.
Okay, we've got a motion and a second. Any discussion from the commissioners? But my only question, and perhaps it goes to Secretary Mahdi, is
You missed it. Commissioner Barnum called it something else.
he called it a notice.
Yeah, well, I guess the motion is to continue it to the 10th with notice going out to the other side that this matter will be set forth and heard on the 10th. I don't know what in order, but I guess I don't have a strong opinion about the language, whether we call it a notice form. But I believe our understanding is that if anyone on behalf of the Bottoms campaign or on behalf of the staff has an issue with the 10th, that they need to make their objection to or unavailability for the 10th known properly in advance of the 10th so that this commission can consider it. So I don't have a strong view on whether we call it an order or a notice.
Okay, well, I will just make the amendment that we change the form to an order because we are granting the continuance. And then in addition, in the order, we also have the rest of the language that Commissioner Barnum articulated.
I'll accept that amendment.
Okay, and so we got an amendment to the motion, we've got a second. And Commissioner Kramer, you got discussion on that?
Yeah, I just had one question on the motion, and I don't know if there's a distinction here again to be raised, but I was jotting down as you were making the motion, and you called it a request for continuance, and I just don't know if we need to be more specific and say that it needs to be a formal motion for continuance, because a request for continuance could be construed as the same thing that just happened.
I will also accept that.
Well, I'll formally make that as an amendment to the motion.
Okay, and I'll accept that amendment.
Okay.
Katie, you got all this?
Yeah. Oh, good. Well, and I'll make sure the order that I sign accurately reflects it. Okay. So is that an amendment to my amendment? And then I'll second your amendment, and so we've got.
And both
All right.
amendments to my original motion are accepted.
Well, good. Any further discussion? Okay. Well, I appreciate the staff working with the Bottoms campaign. I appreciate you guys' hard work in prosecuting this case forward and your diligence in making sure it is properly handled. And I appreciate the commissioners and us being more than careful in considering and making a determination. With that, I will call the question. All in favor, say aye. Aye. All opposed? Hearing none, the motion carries 5-0. So with that, we'll take a recess, a lunch recess. We're right at 12, and then we will reconvene.
Mr. Chairman, do you want to tell Mr. Sheldon that when we're coming back so that they can be prepared?
Mr. Shilna, can you hear me?
Yes, what time did you say?
So we're going to take we'll say a 30-minute lunch break. So let's reconvene at around 12:35.
Okay,
Thank you. Go if you have an update, and we wanted to check in if you did.
Okay. Yeah, and I did want to ask because what we had just for the record, I had initially asked Mr. Lang for a continuance for today and I had a leave of absence from our court here, so but he indicated he wanted to go ahead. We wanted to, but I thought we were obviously going to be able to resolve the case here in the commission here, you know, without having to go have reasons, some of which we've gone into and some of which we haven't, why it didn't happen, but we've turned the information over, and if we can actually get the login information, which I'm understanding is the issue, we can actually have the report filed in proper format by close of business today. So we can actually have everything filed in the proper format today. It was just a delay in getting the information. I just got that information in Mr. Taylor, just as soon as I could, Mr. Lang on over there. So I just didn't understand about all the stuff about 2014 and PowerPoint, and so we were hoping to be able to resolve it somehow today and get that done. Is there any way, or resolve it here at this level? Is there any way to do that?
Well, Mr. Shelnut, we don't serve in a mediation capacity. The issue before the commission is whether there's reasonable grounds to believe the act has been violated. And so really your arguments have to be focused on that issue. It doesn't sound like there's any defense. And if there's no defense and there was no continuance, so this is before the commission as we speak, I would propose that you work with Mr. Lane, but I think a motion is going to have to be made that there are reasonable grounds, and then you guys can work out whether you reach a resolution for the next 30 days before the AG's office receives it. Does that make sense?
Okay, I'm not sure I understand. I'm sorry, I didn't understand. So you're
Secretary Monty, go ahead.
So, Mr. Chestnut, this is what I'm proposing. I don't want y'all to file by close of business. Reasonable grounds to be found for that, but and I'm even happy making it 45 days, where we negotiate and figure out what we need to do, and it won't reach the Attorney General's office if we can do that. But we're not going to be able to sit, I mean, we're going to be here till 3 or 4 o'clock today, I would imagine.
okay. Is there a possibility, just because I did request that we could get a continuance and try to work it out, stated, and then just have it continued off the calendar for today, like I had originally asked for?
Well, we're kind of getting back into the weeds of what we were just dealing with about how there's not really a mechanism.
Because I think you had told me that I was gonna have to request that from there. Today's, and y'all, it's not y'all's concern, today's my wedding anniversary. I'm supposed to be out of state. I'm in big trouble with my wife. I know nobody cares about that, but I had actually filed a leave of absence that's recognized by our court system. And so I had not really anticipated this all going forward like this.
Yeah, well, we understand that, Mr. Shelnut, but reason I believe that the Campaign Finance Act was violated, and I'm going to add the condition that it not be bound over for 45 days to the Attorney General's office, which is going to give you, Mr. Chestnut, and Mr. Baker an additional 15 days to work out. Mr. Shelnut, additional 14 days to work that out. But I will make that motion.
I'll second.
Okay, we have a motion, we have a second. Any discussion?
I just want to make sure that the campaign, the probable cause, reasonable cause is for the failure to file the disclosures from March, June, September, October, and December of 2018.
Mm-hmm.
And I'm not hearing that the disclosures were in fact filed. I know we've had some debate as to what the content was in the disclosure or what it should have been.
They're not filed at all.
Okay.
And then you also have 2 additional charges on top of the failure to file. You have the failure to disclose contributions and expenditures totaling $21,000 plus. So there are 7 charges in total.
Okay, any other discussion? All right, hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay, motion carries.
Abstention 1.
Abstention, okay. So we've got 5 in favor, which is Chairman Evans.
4.
4. Man, thank God I went to law school, guys. 4 in favor, Chairman Evans, Vice Chairman Cranville, Commissioner Watts, Commissioner Thompson, and then Commissioner Barnum abstained, and that's for the minutes and for the record. Mr. Shelnut, we appreciate you coming. Mr. Baker, we appreciate you coming. I encourage you guys to reach out to the commission staff and try to work through this. You guys, no, we're no longer needed for today. You're welcome to stay if you want to, but this case has been concluded.
And Mr. Shelnut, if you want to reach out to us early next week, we can get working on this and get this.
I'll be in touch. Thank you very much, and y'all have a good weekend.
Okay.
Thank you, sir. All right, so next we got, in the matter of
Commissioner, General Assembly. This case was sua sponte filed by commission staff, and, excuse me, and the allegations are that Ms. Tate failed to timely file her personal financial disclosure statement for 2018. She failed to timely file her teen campaign contribution disclosure report. She failed to file her June 31st, 2019 campaign contribution disclosure report and her June 30th, 2019 campaign contribution disclosure report. And then finally, we've alleged that she failed to disclose $2,400 in campaign contributions between the period of September 1st, 2018 to January 31st, 2019. Ms. Tate is represented by counsel, Mr. Matthew Weiss, Parker Hudson. The parties have entered into a consent agreement. The agreement is that Ms. Tate will pay $3,400 in civil fee late filings, $750 for each of the failure to files, and then $1,300 for the failure to disclose. That's how we get the $3,400. And she has already previously paid her outstanding late fees in their entirety, so they have not been addressed as consent order. Since the parties have come to an agreement, we respectfully ask that the commission adopt consent order as proposed.
okay, is Mr. White's here or virtual?
No, he asked if he could be excused since the parties had agreed. If he's needed, we can get him, but he preferred not to in the same Ms. Tate.
Did he file a leave of absence?
He did not file a leave of absence or a request for continuance.
All right, commissioners, any questions? And just to be clear, Ms. Tate was served, Ms. Tate has signed off on this, and her counsel is aware and signed off on it.
That is correct.
All right.
And just, Mr. Chairman, just for the board's edification, what we do when it's a member of the legislature or a office holder, particularly downtown, we send notice to the residents. We also send it to their legislative office or their official office. So we double serve that.
Good. All right, well, I will move that we adopt the proposed consent order in the matter of Horacina Tate. All right, motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay, carries 5-0. And next, Mr. Lane, in the matter of Vernon Jones.
Commissioners, with respect to Mr. Vernon Jones, which is case D on the agenda, as well as Mr. Osborne Nesbitt,
Make that motion. I move that we continue the matters or we have a Commissioner Barnum. Go ahead.
I'll wait for the motion, Mr. Chairman, and then
Okay.
I'll ask my questions.
I will make the motion that we continue in the matter of Vernon Jones and in the matter of Osborne Nesbitt on the basis of their counsel's passing in the family.
Second.
All right, we got a motion, we got a second. Man, the continuances are a ground of dispute. Any discussion?
Yeah, so, Mr. Chairman, I do have some questions. All right, so, Mr. Lane, wasn't Mr. Nesbitt's case continued from the last hearing?
it was, yes, sir.
Okay, and what was the grounds for it being continued from that hearing?
Mr. Thomas was in court on another matter. He had submitted a proposed order of appearance in which he had 4 cases in front of us. 2 were criminal and 2 were civil matters, and he just did not cycle through the court system fast enough to get to us. So I guess it was continued by operation that he didn't, we wasn't able to appear.
Okay. And it's being continued this year because of death in the family.
Correct.
So I believe there's somebody you out of the room when we had a robust discussion earlier.
Oh, no, I caught it. I
Okay.
may have been hiding behind it.
Okay, maybe I just didn't see. But it certainly strikes me that with respect to Mr. Nesbitt and apparently with respect to Mr. Jones, I don't know how their request for a continuance was communicated. Did they send a letter, a correspondence?
It was a-
They certainly didn't file a motion.
No, they did not file a motion. It was a correspondence from the attorney's record, basically detailing that his father had passed away, I want to say Tuesday of last week,
Mhm.
and that funeral arrangements were in the process of being made, and they were in the process of attending to his final affairs.
And what about last time? How did he communicate his request for a continuance?
He sent an order of appearance, the notice of conflict. So
Okay.
he followed the notice of conflict rule and Uniform Superior Court rule. Forgive me, I have not followed them in some time, but he followed the Uniform Superior Court rule for a notice of conflict when you have multiple hearings on the same day.
So do the Uniform Superior rules apply here or don't?
They do not apply.
But so I'm confused because in your objection that you filed to the notice of legal as the basis upon which this commission grant a continuance for Mr. Nesbitt.
The commission granted it right when we heard it. If I remember correctly, we waited to the end of the day before the case was continued. Because throughout the day, we continued to check if Mr. Thomas was still in court as he had previously disclosed.
Well, do they apply or don't they apply?
The rule itself does not apply, but this is where I've made the distinction, if you'll permit me. The distinction being that they apply in Superior Court. And if Mr. Thomas does not appear in Superior Court as ordered, the court can issue a warrant for his arrest and the deputies can come get him, whereas this commission does not have that authority. So it's better to ignore us than the Superior Court. So it's not that.
That secretary body.
It's a matter of.
So there's a secondary distinction here, and I don't want to relitigate this issue, but in the Keisha Lance Bottoms case, we reached out to the clerk of court. Feel that it is not in good faith being made, that this is 10 months in the making. And whether you agree with me on that or not, I think that's an important distinction that all they were alleged to exist.
Well, okay, so I want to make sure because earlier I thought I heard you say, Secretary Lonnie, that calls had been made to the courts of those other cases and they didn't have any record of a leave of absence on file.
Or hearing.
Okay.
As of Tuesday, that was what we were told.
Okay, all right. Because I want to make sure that if you're
He's not in the state of Georgia, so he's not appearing at any of those. They don't have hearing dates.
understood. Because I am confused at the apparent ease with which a continuance can be supported by our staff attorneys in some cases, and in other cases there seems to be a conflict with granting what is in effect a request for a continuance. To the point we were discussing earlier, there doesn't seem to be any protocol or process or established procedure for the comes down to discretion of our staff attorneys as to when a continuance is or is not going to be supported or granted or recommended to this commission, and I find that troubling. system process to request a continuance, under what circumstances a continuance will be granted. Consider.
And we're slowly working all that out from the attorney's fees perspective to this, but pending before the commission is this motion to continue these two matters. Do we have any other discussion? Okay, hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, this is up to Mr. Gregory Sheaton?
Yes, Shenton.
Shitton, okay. And is that you too, Mr. Lane?
Yes, sir, it is.
All right, go ahead.
Commissioners, you have two cases in the matter of Mr. Gregory Shenton, 2020-51 and then 2020-52. Turn to case number 51, which will be the more important of the two. This case began on August 12, 2020, was filed sua sponte by commission staff. The allegations are that Mr. Shenton, who is running as a candidate for Cobb County Superior Court, expended $6 over the contribution limits because he accepted multiple donations which exceeded the limits and came from a single source contributor. That single source contributor being the law firm of Odell and O'Neill. In speaking with Mr. Shenton, Mr. Shenton took remedial measures. He refunded $1,300 back to Odell and O'Neill. Additionally, he refunded an additional $5,600 that he believed were coming from single source contributors, but upon further review were not single source contributors. So he should have been able to keep them. In light of the fact that he returned more money than was required under the Act, Commission staff reached an agreement with Mr. Shenton to impose a $120 civil penalty for that violation, the consideration being that he had self-punished himself for an additional $5,600 that he was not required to refund. That is the resolution for case number 20-0051. As to case number the three allegations regarding that are that Mr. Shenton had a political contribution to the local county Republican Party, and the complainant so in the commission staff noted the second allegation was that Mr. Shenton held a fundraising event contributions related to that event. So again, no violation, nothing to disclose. The final allegation is a mirror image of the complaint filed by commission staff, 51.
Are these all in the same consent order?
No, sir.
Okay.
52 is an administrative necessity. Just forgive me.
Okay.
And as to allegation 3 is resolved. Case number 51, which is a $120 civil penalty for exceeding contribution limits.
Okay. And the administrative dismissal, we don't need to take any action on.
Correct. You only have to take
This is his signature.
and he's happy.
All right. Commissioner Barnum.
Actually, Mr. Chairman, I'd like us to resolve this particular matter, and then I'd like to go back to the matters of, Osborne Nesbitt Senior and the matter of Vernon Jones, if we can't actively resolve this matter.
Okay. Well, the problem with that is if they're closed,
request to reopen those matters and a modification of the decision of this commission. I can address that now, Mr. Chairman, if you.
Well, let's finish
Okay.
out the Shinton and then we'll get. Okay, but Mr. Shinton received notice, he signed it, this is his signature.
Yes, sir.
Okay, just want that on the record, thank you. Any comments by the commissioners? Okay, I will move that we adopt the proposed consent order in the matter of Gregory O'Neill Shinton.
I'm sorry.
Yes, sir.
I have one question.
Well, can we get a second and then do discussion?
I'll second.
Okay, we got a motion, a second, and then we got discussion, and Commissioner Watts has got a question.
Just in the case number 50, and in the last paragraph of his response, he said, respondent notes, in this case, respondent was only served with the original complaint filed by William Atkins and was not served with a separate complaint drafted and signed by the commission as case number 54C. Did you ever resolve that, whether he was
He
actually
was
served?
served, we provided him notice, it was signed by his assistant at his law office. Yes, by overnight mail, so.
But he clearly has willingly entered into these. Okay. All right, that's all.
Okay,
And just as an FYI for the commissioners, for Metro Atlanta residents, it's actually cheaper for us to use overnight UPS service as opposed to postal service. So for the vast majority of our folks, they're getting overnight UPS delivery, which is much easier for us to track and cheaper. So, go figure.
all right. Any other comments, questions? Okay. So we have a pending motion. I will call the question. All in favor, say aye. Aye. All opposed? All right, hearing none, motion passes 5-0. And then Commissioner Barnum has a motion and comment.
Yes, Mr. Chairman, I move to reopen the matter of Osborne Nesbitt Senior, matters 2016-0022. Motion that the commission issue an order to Mr. Nesbitt and his counsel to appear at the December 10, 2020 regularly scheduled hearing with the same or similar language ordered in that of the matter of Keisha Lance Bottoms, in light of the fact that Mr. Nesbitt's matter has been continued in that order that was approved by this commission in the matter of Keisha Lance Bottoms.
I'll second that motion. I think consistency and all in favor, say aye.
Aye.
All opposed? Okay, motion carries 5-0, and let's just make sure the record reflects that amendment, or would it be an amendment? Reopen and then
Superseding orders.
I think that's
superseding
correct.
order?
Yes.
Okay, got my parliamentarian.
Yeah, Commissioner Barnum,
Hold on. All right, Secretary Martin.
Commissioner Barnum, I think you make a good point. I would recommend a motion be made to do the same for Mr. Vernon Jones, who is also represented by the same
I
attorney.
think you had both.
Well, and the only reason I didn't mention Mr. Jones's matter, because I don't think that he had been granted multiple continuances. Is this his first continuance?
It is his second, but his first continuance was granted because of legislative privilege.
Okay, then I would add Mr. Jones to that as well. Do I need to remake the motion?
Let's.
It's a different case.
Yeah, different
Okay.
case. So we've
Right.
got Mr. Nesbitt's matter, and then if you want to remake the same motion for Mr. Jones.
Sure. Mr. Chairman, I move to reopen the matter of in the matter of Vernon Jones, case number 2019-0035 PC, for the purpose of amending or entering a superseding order to have Mr. Jones or his counsel on behalf of Mr. Jones, that they be ordered to appear at the December 10, 2020 regularly scheduled meeting, and that similar language that we discussed in the matter of Keisha Lance Bottoms Mr. Jones and his counsel.
Okay. Got a motion and a second. Do we have any discussion? I will call the question. All in favor, say aye.
Aye.
All opposed? All right, motion carries. So next we've got, in the matter of Tammy Bailey and Mr. Cusack, it looks like you're up.
Yes. And this one is case number 2019-0061 in the to the Doraville City Council in a special election that was held on November 5th of plaintiff in this case to accept legal contributions. I checked those, her CCDRs. She actually raised under $2,500 the whole time, so there was no way she accepted above the $2,800. But in getting her CCDRs from the city of Doraville, both of her filings were late. So she has entered into a consent agreement to pay dollars to the commission for filing both of those late. She then terminated her campaign after the December 31st filing, which was late. So about mid to late January is when she terminated her campaign. So this was a complaint that came in, and but for me having to check on the CCDRs, we probably would have never known it was late, but this is what she's agreed to pay those late fees. She admitted they were late. She did not want to be present today, but she was served with notice of this hearing.
Okay, commissioners, any questions? Electronic signature?
Yes, it is. I believe we received it earlier this week.
All right. I prefer that we get hard, wet signatures going forward. Just
I believe she may be turning in a signed copy that we may be getting to you, but this is when she got back to the commission right away because she realized she wouldn't be able to get it here by today.
okay. Well, let's get that wet signature. Otherwise, I'm not going to sign the order. But all right. Any questions or comments?
Second.
We got a motion and a second. Any discussion? Hearing none, I will call the question. All in favor, say aye.
Aye.
All opposed? All right, motion carries 5-0. And next, and I think this is last for the preliminary hearings, is in the matter of Nikita K. Hemingway.
And this is going to be a consent order. This is the matter of Nikita Hemingway. There's two case numbers associated with this case, 00038-C and 200048-C. Both of these cases stem from two third-party complaints that were filed by Garrison Douglas. One was filed on July 1st of this year, and the other was filed on July 28th of this year. The first complaint deals with the first paragraph, or the first two paragraphs of this consent order, in which it is alleged that Ms. Hemingway did not file a personal financial disclosure statement. In this case, I went back and forth with the Hemingway campaign a lot on this consent order, so some of the language put in there is not my own. It's part of the agreement I've reached with them. But what happened is Ms. Hemingway came to our office and just filed a bunch of documents, never filed the PFDS, and she is running for the House of Representatives in House 104. She has to, by statute, file that online through our filing system. In this case, she dropped a bunch of documents off at our office. The PFDS was incomplete, but that was one of the documents. However, we're not allowed to accept it that way. She then tried to email one of our education employees that PFDS, which wasn't filed on time, but she never actually filed within that 15-day range from qualifying You have 15 days to file the personal financial disclosure statement. She did not file that online in our system until about it was late. So that's why part of this is the not filing that in a timely manner. The second allegation in here that they've agreed to is that there was two-day business reports that were filed in between the time this year. We had sort of a unique set of circumstances this year with the primaries being pushed back to where they were in June. So that left the last filing in March until the June primary as days where you had to file that 2 business day report if you received a contribution over $1,000. So she actually loaned her campaign $1,000, or loaned her campaign $1,750 on May 22nd and failed to disclose that. She did, in mitigation, loan her put this loan on the June 30th CCDR. So that's part of this consent order, but that was one of those things like with Ms. Gonzalez, it wasn't figuring into her filing. So the next portion of this consent order deals with the last part that the campaign has agreed to, in that she accepted contributions before a declaration of intent had been filed. Of intent to accept campaign contributions was filed on March 13th of this year. And in her first filing, she listed 2 contributions in the amount of $400, which was dated on March 5th of 2020, about a week prior to when she filed her DOI, and on March 11th, 2020, about 2 days prior to when she filed her DOI. The first amount was for the $400, it was reported as an in-kind contribution. The status of this changed in their filing, and it's changed again. But that was for the qualifying fee for this seat. So she reported that as an in-kind contribution. The campaign wasn't in existence then. So then they changed, they believed that she paid it out of pocket. They tried to say that she paid it out of pocket. But at this point, the characterization of it just changed so many times that it was clear that it was originally an in-kind contribution or it had been reimbursed. So that was so there was $400 that was expended and reported as an in-kind contribution before the campaign exists. The under $150, which occurred 2 days before, was for an incorporation of the campaign. And so that was reported as an in-kind contribution as well. So you have a total of $550 that was taken in by the campaign as either an in-kind contribution or what could be termed as a loan to the campaign before the campaign existed. So those are the reasons for the violation there, is that these were reported as in-kind contributions before the campaign existed, and then a complaint was filed, and then they've tried to since rectify. They changed the definition of what they understood these contributions to be. But anyway, they don't exactly agree with, and I think it's in one of the notes here is their understanding. They want to basically enter into what's like an Alford plea. It's in our best interest to take this as opposed to fight this, because they think they're on one side of the law, but they think that this shouldn't have had to been disclosed, even though they disclosed it, but they want to enter into this agreement. And my position is this was money taken before the campaign, disclosed, and then when you responded, you said it was actually reimbursed. You can't reimburse yourself for an expense for a campaign that didn't exist. So that's why we've sort of met in the middle here, and they're agreeing to pay a $500 fine to settle this case. So that's, I'd ask the commission to adopt this consent.
Okay. Commissioners, any questions, comments? All right, I know you just said that they disagree with it, but they understand they had an opportunity to defend it, oppose it, and they consented to it nevertheless.
Yes, I think as opposed to chancing it and having a higher fine down the line or just stretching this out, they've taken this, they just wanted to enter into this and sort of, before expending any more.
Secretary Monty, Alford is it's a criminal term of art in case law that essentially means we don't believe we violated the law, but we don't think we're gonna win at a vote, so we're just gonna do this in our best interest. And so that's essentially what they're saying is, we don't agree with your interpretation of the law, but we don't think we have a good enough chance of winning to dispute what you're alleging.
And I worked with them on the language here. I think it's obviously an election year for them, so I was happy to work with them on the language here to ease their concerns, and they ultimately entered into this. So that's sort of why that footnote was in this consent order.
Okay. And that was her request to add that.
Yes, and there's some,
Respondent does not agree with the conclusion. That one, footnote
Yes.
2.
yes.
All right, commissioners?
Point of order. Can we call it a consent order with a footnote that says that they don't agree? And I'm not suggesting, do we just change the name? I mean, is it?
Interest is what they're saying is this is in our best interest to take this deal because this deal might not be on the table if we lose. So we'll take a look.
And I get that. I guess my concern, Mr. Cusack, is they're suggesting that they also don't agree with some of the factual allegations, right? I mean, they're pursuing this as a matter of expediency.
Yes, I don't think factually, I think everything's in agreement factually. I think their interpretation of what this actually is what they're confused on. I went back and forth with them a long time, and they don't seem to grasp that when they put this down prior to the DOI, that the campaign ceases to exist. Can't make a contribution to it. And they're like, and the reason I'm saying that is because the characterization, it has changed so many times of what this, was it a contribution, was it out of pocket, was it reimbursed? Where I wasn't comfortable saying it was out of pocket. So that's what they're saying is that this could have been out of pocket, and we've said, you can pay your filing fees out of pocket, of course. But the characterization of this has changed.
So what Commissioner Barnum was saying, I think is right, because I was trying to equate it to a settlement agreement in my head. And in a settlement agreement, every single time we sign one, we say we don't agree with anything. But then I was thinking, okay, well, when we file the settlement agreement with the court, it's not a consent motion, it's an unopposed motion for them to preliminarily approve, the judge to preliminarily approve settlement. So I guess my question is, instead of making this a consent order, which I don't know what you're going to have to do with the respondent after I say this, if anybody agrees, but an unopposed motion to accept the penalty. I mean, but then it's a penalty, so they're not going to agree to that.
The problem is the motions are, the motions are typically made up here by the commissioners, so I guess we wouldn't oppose each other's motion.
All right, Commissioner Cranville.
I'll go back.
I would just say best practice. We've got respondent does not agree with the conclusion that the act of disclosing or out-of-pocket expenses results in an ethics violation. Then she says in the same footnote, respondent submits to the conclusions reached herein that the commission insists that the act of disclosing such in-kind contributions is itself a violation. I don't know what to do with that. I really don't.
So going back to we maybe just be overthinking
Yeah, we could.
Consent to the plan.
Yes. I mean, it's essentially a contract between two parties and
And I understand, I think it is. Okay.
And I just to make sure, for the record, explain why she signed something, right, that has and call it a consent order.
yeah. Entered by consent order, so they're fully aware. It's just fine consumption language that can't. I know it's not the best practice, but it's what pushed this case across the finish line.
Is there an order? I mean, is there a motion on the floor?
No motion.
Okay.
No.
Then I move that we, in a matter of Nikita Hemingway, case number 20-0038-C and 20-0048-C.
Who wants a second?
Second.
He's got it. He beat you. All right, we got a hearing none. I'll call the question. All in favor, say aye. Aye. All opposed? All right. Motion carries 5-0. Administrative dismissals. So we got Mr. Lane first, and let's try to shoot through these unless you think that there's anything. Maybe Mr. Balfour, given that we can talk about that one at length, but the rest of these.
I'll give you bare bones unless y'all want more. Okay, for Mr. Davis Fox, it's actually a complaint filed against Mr. Davis Fox, Mr. Burrell Ellis, Mr. Burt Brennan, Mr. Joel Gottlieb, DeKalb County, and then No Brookhaven Incorporated. This is a case that was filed, back in 2012 by J. Max Davis. Mr. Davis alleged that all of the respondents violated 21-5-30.2, which is the government contribution section. His allegations centered on the fact that all of the named individuals sent emails that had the name Brookhaven City Initiative within them. It was officials discussing the pros and cons of the cityhood initiative, how the DeKalb County government could oppose it, how they could provide better services for residents of Brookhaven. There was no overt electioneering. It was simply public officials and employees exercising the duties of their office. As this commission recently dismissed the Casey Cable complaint for very much similar reasoning, we dismissed this complaint as well, that the exercise of a public office by public officers does not constitute campaign contributions if there's no overt electioneering or electioneering of any kind. So for that reason, the case against Mr. Fox et al. Was administratively dismissed.
Okay.
As for Mr. Michael Julian Bond, 2007.
I've seen that name before.
You have. You'll love this one. In case number 2017-0206, Mr. Emerson Gerardo filed a complaint order. As this commission is well aware, you handled 2009. But also, the commission staff dismissed this complaint, as we have argued successfully multiple times, that complainants do not have legal standing to enforce any orders with this commission or to force us to take any specific act with the enforcement of orders in prior cases. So for that reason, the complainant lacks standing.
So how does this relate to the pending ones? The ones that we have discussed at the last one?
His civil penalty payment.
But no, I mean procedurally, how does this relate? This is a completely unrelated. Okay.
Completely different.
Okay.
It's literally just, he's missed his civil penalty payments, you need to sue him to make him pay. Is what the complaint basically boils down to.
Okay. Got it.
So. And I'll take care of them last time.
Who filed that?
Mr. Emerson Gerardo. I'm not sure who that is. He's not there, Mr. Hall.
Okay.
The last one for myself is in the matter of Evans for Georgia Incorporated 2018-0039. As everyone knows, Miss Stacey Evans was a gubernatorial candidate in the 2018 race for Georgia governor. The complaint was filed on April 25th, 2018 by Miss Lauren Grove-Wargo, who is Miss Stacey Abrams' campaign manager. The allegations center around an organization called Hope for Georgia Incorporated, which was headed by Joshua, Mr. Joshua White, thank you. And Mr. White is a former campaign staffer that had been released from his employment about 6 months prior to starting Hope for Georgia. The allegation was that Hope for Georgia was somehow coordinating campaign fundraising expenses. In reviewing the disclosures from Hope for Georgia, as well as their communications and financial records of both Hope for Georgia and Evans for Georgia Incorporated, there was no coordination, there was no joint fundraising, there was no expenditures, there was no electioneering activity, there was no expense. Hope for Georgia then funneled that money to other 501c4s and 527s, which then proceeded to disclose their transactions accordingly and lawfully. There was no violation of the Campaign Finance Act by Hope for Georgia, and therefore there is no violation by Evans for Georgia Incorporated. So there were no violations, and we dismissed.
Who did you say filed that one?
Miss Lauren Grove-Wargo, Miss Stacey Abrams' campaign manager.
Her own campaign manager filed a complaint against?
Stacey Abrams, the opponent.
Oh, Stacey Abrams. Okay, got it. Difference. Go ahead.
But no, that's it. There was no violation, and we dismissed.
Okay, Mr. Cusack, you're up next.
And would you like to hear Mr. Balfour's first?
Balfour's last.
Okay.
They're gonna have questions.
That sounds good. All right, the first one for the administrative dismissals is in the matter of Emmanuel Ransom. It's case number 2013-0043. This case came in as a third-party complaint on October 31st of 2013, and it alleged that Mr. Ransom, who was then the mayor of Clarkston, had accepted $500 in anonymous contributions. He was very adamant that he had lived there for about 40 or 50 years. So he was confused as to why the initial documents didn't make it to him. He also filed a response, and I termed that in this as it seems to address the $500 anonymous contributions, in that he filed his October 25th CCDR as a response, and those contributions add up to $500 and list the contributors. And also, investors reached out to him with our office, and we were trying to see if he would file something else or if he could pay. And we've learned that he's 83 years old and lives on fixed income right now. He's out of politics. So we've chosen to administratively dismiss this because of the age of the case, and due to his advanced age, it doesn't really seem like a good use of resources to try to figure this one out. So and it seems that $500, in talking to him, it was very difficult to discern sort of what he was saying, but it seems like that $500 on the October 25th CCDR that he filed is meant for that $500 that was for John Doe. So that's why this one was administratively dismissed. Would, in which he alleges 035-C. This was a third-party complaint which was filed on September 9th, 2020 against Gerald.
Okay.
The next one is in the matter of Natalie Payne. This is case 20-0064-C. This was a third-party complaint filed on September 9th, 2020. Reviews. Basically, it's a memorandum of understanding to discuss any cases that may be suspicious and sort of pool all their resources. But it is not a funded group. Having come from the DA's office, I know how these work in that they're not funded. You're just sort of a specialized unit, and you do that to sort of meet the needs of whatever in your community you're having tough times with. So there may be gang units, there may be a child fatality review to look at every single child fatality in the community. But Augusta seems to have an issue with elder abuse or elder homes that are unlicensed.
Okay.
So this is what they chose to do.
Okay,
So
here's what I've got.
this is not an agency that would meet the definition of giving a contribution under 30.2 or an agency contribution. So that's why this one is
When I
being
go to your
dismissed.
link on the website, I see what you're saying.
Yeah, Mr. Chairman.
But this is messed up, dude.
So, I didn't come from a DA's office, and I am curious about how we define agency. So, did Ms. Payne create the CAVE task force?
Yes. Now, it is created through and task force would probably be the best way to put it because it's completely volunteer based. So the DA's office can put it together by legislation, but it's not funded in any way, shape, or form. It's just sort of a loose meeting of people. So say you had like a gang task force, you could have people from the GDI or people who run community groups to combat gangs in that group. So it's sort of like a formalized meeting where you can have people there who have specific knowledge for the group that it's trying to combat or trying to help.
Okay, so an agency, being the DA's office, created this task force, right?
Correct.
It's not funded.
Correct.
Does the definition of agency in the state of Georgia require some state funding?
It would have to be so it's not an agency. So an agency would be like the Campaign Finance Commission or the actual sheriff's office or the DA's office, but there's no funding. It doesn't require, I would say funding is something that would be required in terms of when a contribution can be made, but.
Well, wait, those are two separate concepts.
Okay.
So when a contribution is made to a candidate, perhaps some funding, or in this instance, I mean, maybe it was, I don't know whether it rises to the level of contribution by what they did on Facebook here, but I want to stick with the definition of agency for a second. So in footnote 2 of this recommendation for administrative dismissal, you define agency and under OCGA 21.530.2, and there's no funding requirement. correct?
Correct. I
So,
don't know if I know of an agency that isn't funded though.
sure, but the definition of agency under state law can include such things as a authority or similar body of each such county or other political subdivision, or perhaps every city, county, regional, or other authority established pursuant to the laws of this state. So OCGA 3511 allows a DA's office to create a task force such as K.
Yes.
And where is the line, or has any research been done to determine whether a task force such as K, established pursuant to laws of this state by an agency to assist specifically the agency with the work they're performing, whether or not that rises to maybe not a quote-unquote sub-agency, but a political subdivision of the state, or similar, or other authority established pursuant to the laws of the state. Has the commission looked into that?
I haven't looked into that specific issue, but I think it and it may be a very fact-specific question. Here you have somebody, and I looked at the memorandum of understanding. You have a bunch of different community groups, and this sort of gives them legal cover to discuss privileged information that may not be public. So say, in this case, DFACS had done, DFACS or somebody of the like law enforcement can come to one of these meetings or share information, and it might be a group home or something like that, and the police can say, well, we've had a certain amount of calls to that group home. And they're able to share this information freely to better the community, as opposed to actually being sort of operating as an agency. So it's more of a sharing of information in a way where you're not going to be legally liable if that information, there's no way to share that information. It sort of shields them in that way, so they can share that information to sort of combat those problems in the community, if that makes sense.
Okay, yeah, I mean, I appreciate what the organization does and what these types of entities can accomplish, but isn't it true that also that CAVE specifically is made up of various law enforcement agencies, state agencies, and community organizations?
Yes, that's true.
So the membership of CAVE, while perhaps in your view not an agency under the laws of the state, is made up of what is indisputably at least several groups that would fall under the definition of agency of the state, of the laws of the state of Georgia.
So agencies would be, I guess agencies could be members, but then you also have community groups that can be members. So it's not, you're not creating an agency out of nowhere here. They're not coming together to be an agency.
Right, but there's a lot of case law out there, maybe not just in Georgia, but in a lot of places that discuss when an entity arises to such things as the political subdivision of the state or other authority established pursuant to the laws of the state. And I am uncomfortable with, unless the commission can give me, or the staff can give me a better understanding of what meets or doesn't meet that threshold, of saying that CAVE, for example, is perhaps beneath the threshold, particularly when CAVE is made up of members, at least a subset of its membership, are indisputably agencies.
Right.
So if CAVE then, made up of members that are agencies, makes a contribution, putting aside, because you can make the argument about whether this was a contribution or not, or a violation, and maybe outright that CAVE just doesn't meet that definition of an agency, when if a contribution were to have been made the underlying members are undisputably agencies.
Yes, and I can probably do some more research on that subject. However, when you get into the makeup of these organizations where you have non-agencies or non-government entities involved, they're not acquiescing to being an agency. So and maybe it's more research on my part of determining when it actually becomes or could it become an agency. But here, the makeup of this specific organization actually wouldn't rise to meet the definition of agency. But I know Mr. Amati's chiming in because I know we have these groups in the DA's office, and he may be able to further eliminate some things.
Secretary Monty. So, you can back up here. And this is not a good look on me, but Joe, I'm going to have a question for you. Isn't there a requirement?
Yeah, you know, sorry.
Okay.
Sorry, Commissioners, if you'll permit me. The K Task Force doesn't rise to the level of the threshold of an agency because it doesn't exercise any state power. It is a grouping of officials, community members, and other interested individuals who meet on a regular basis, sit in a room, they talk about issues that are coming up, things that they can do to better protect vulnerable people. They're not exercising state power. And as far as case law, the case that springs to my mind is a recent case involving a sub-sister agency of ours, the DeKalb County Ethics Board, in which former Governor Barnes successfully argued that its current constitution was unconstitutional because you had nonprofit members joining that board and exercising authority of the subdivision of government of the county. That they weren't elected by members of the public, nor were they appointed by elected members. In the most recent iteration of the legislature trying to resolve and correct that deficiency, they were trying to make it to where the nonprofit members were replaced by appointees of, I believe, the legislative delegation, if I remember correctly. That being the lawful appointees could be from members who were elected. But my understanding on the K Task Force and all these other task forces, they're not created by enabling legislation. They're created by memorandums of understanding between various different agencies, community groups, people. So they're not getting to that level of state power. So that's why I'm not considering them to be an agency for purposes of a 30.2 coverage. And additionally, they don't have anything to contribute because the vast majority of them have no funding, with a few exceptions.
So maybe funding isn't the right distinction, then under your view, the right distinction is of a political subdivision or other authorities established pursuant to the laws of the state would be an entity that had any authority of the state to enact.
Yes, sir, that's correct. Now, I'll confess, I came from the DA's office too, but many, many years ago. So I'll defer to the newer people from the DA's office. I don't know of a single K task force that can exercise state authority.
And so that's another sort of distinction I would make, Commissioner Watts, is while Natalie Payne may have organized the coalition of some government, some non-government entities, Natalie Payne doesn't exercise control over what the K Task Force necessarily does. It's an MOU of a bunch of various individuals coming together. So,
Purpose as well.
And that limited purpose, and you read the MOU.
So what they do is they have various different sort of elder abuse or in the elder, I guess, care community. And that's what they're trying to combat is elder abuse or vulnerable people who get taken care of that are vulnerable in the vulnerable community. They have those organizations there to try to, I guess, information share, to know where investigations should be targeted, anything like that, or where sort of this behavior is happening and what they can do in the community through various community groups or through law enforcement to sort of help with that.
The DA's alumni in the room, it's more of a sounding board.
Exactly.
and the other issue with the 30.2 violations, if you look at the definition of contribution at the very end, the contribution has to be done for campaign purposes. And this doesn't touch on that. It may tangentially benefit her if the crime goes down, but that's not the purpose of the collective of the various elder abuse task force members.
Well, either way, under Mr. Cusack's view, it wouldn't be a contribution.
Correct.
Okay, thank you.
All right, now the one you've all been waiting for. This one is case number 2018-0098. This is in the matter of Donald.
Commissioner, hold on one second. Sorry, Mr. Cusack. Commissioner Cranville?
Before we get to that, I was kind of holding my comments on all these administrative dismissals until the end. I know there's going to be a lot of questions on this one, so I just want to make my comment very briefly. I want to go back to that Emmanuel Ransom case.
Yes.
I just want to go back to something that you had mentioned, part of the reasoning upon which you were recommending for administrative dismissal. Now, I jotted down in my notes that you weren't, and I hope that this isn't going to be the case, that we're not going to fail to pursue, any of these cases based on an individual's age or income. I mean, I know that you said that was part of the reason in that case. I see the problem with that case being that the age of the case and service as being the problems. But, when we start talking about age or income, I just don't want to open up some can of worms. I mean, that's what the hardship provisions are in the Act for. And I don't want to use a person's age or whether they're on a fixed income as a basis upon which to base an administrative dismissal.
Correct, and it had to do more with the age of this case. I mean, that case came into office when I was still in law school, so it had reached a point where a decision needed to be made, and I believe that was the just decision given those sets of circumstances there, the age of the case. Right. This one is case number 2018-0098 in the matter of Donald Kenneth Balfour and committee to re-elect Balfour. This case came in via a third-party complaint on August 18th of 2018. It was a complaint filed by William Perry against Mr. Balfour and the committee to re-elect Balfour, in which he alleged that Mr. Balfour had violated the act by failing to continue to file campaign contribution disclosure reports after he was the unsuccessful candidate in the May 20, 2014 Republican State Senate District 9 primary election. Just to go over the law on this, when a candidate is an unsuccessful candidate in an election and still has leftover cash on hand, they must continue to file that election year CCDRs, but after that, they need to file by December 31st of every year after that if they have cash on hand. That's just a quick summary of OCGA 21534 I2. In the present case, respondent, Mr. Balfour, finished his unsuccessful re-election campaign with cash on hand and continued to file campaign contribution disclosure reports.
How much cash on hand was there?
About $650,000.
Yeah.
And he continued to file for the rest of the election cycle in 2014 after his defeat. He filed his last report with the commission on December 31st of 2015. And that last CCDR listed at about $650,000 in cash left on hand. And there's been no CCDR filed since that date. To get where we were, this is why, to save this case, this was one of the steps we tried to take. On November 14th of 2019, I filed a notice of inspection to inspect Mr. Balfour's campaign records. And Mr. Balfour, who's represented by Mr. Chalmers in this case, alerted commission staff that more than 3 years had passed since the campaign account had been terminated, and those records no longer existed, and nor had to be maintained by the campaign due to the amount of time that had lapsed. And he relied on OCGA 21532C, which states records of such accounts kept by the candidate or campaign committee shall be preserved for 3 years from the termination date of the campaign for elective office conducted by the candidate or of the campaign committee for any candidate. So that was one of the steps we tried to take to save this case, to try to figure out where this money has gone. I'll continue with this AD in that Mr. Balfour served in the General Assembly and was running for office. He has a 2-year term, and so the statute of limitations is 3 years from the date of filing on that. And this is where we're getting to a portion of our law that I believe Mr. Amati can elaborate on, that we are actively trying to change, because the way this case played out, if you don't file a CCDR, it reverts to a 1-year statute of limitation. And in restricts us because it doesn't mention failure to file. And we've had some cases that have been interpreted by
But the
us.
one-year statute, I mean, it applies to discovery, right?
It applies to the filing. But as far as the substance of what is filed, it's cold because we would have no way of knowing whether it was filed or improperly filed.
So then, from this opinion, all actions by informers to recover any fine, forfeiture, or penalty shall be commenced within 1 year from the time the defendant's liability thereto is discovered.
Now, that has been imputed on us that we should know. Since we have the system, it's reported to us, or it's not reported to us, that within a year, since we are the state agency that collects the filings, that we should know, or we are on notice if it doesn't, if it's not filed within a year, that we're SOL.
Hold on, what? Say that again?
It's a punt from all punts.
Yeah, I mean,
Yeah, so,
you're on the record, remember that.
yeah. Perhaps Mr. Lang.
Commissioners, this issue has actually been litigated at the lower courts. And what the lower courts have found is that we are imputed to know that a non-filing has occurred when filers use our system. Because our system is supposed to auto-flag that John Doe has not filed. Therefore, we are on notice and our 1-year statute under the informer statute begins to run. There is an exception, and I argue that for local level officials who don't use our system. If the local clerk does not notify us that it's filed, then the statute or the statute of limitations is told until such time as we are notified that non-compliance has occurred, and then our 1-year statute begins running again. It's just also like for Mr. Balfour, we might have been able to save the case if we could have shown what his non-disclosures within those forms are. Because, for example, I'm thinking of Mr. Oxendine. He didn't disclose any of his transactions.
Yep.
Therefore, there was a fraud upon the commission. And then when we discover that fraud, the statute begins to run again. So that's how that 1-year statute interplays, and that's how lower courts have interpreted it towards
Disconnect
us.
you, but not
If
the
you're using
call,
our
okay?
system and you're on notice that no filings are done, the statute begins to run, you have 1 year from a failure to file report to punish for the non-filing of that report.
So your position, what the law says is that it is a discovery rule statute of limitations, but you are imputed to know or discover that there's been a failure to file based upon the fact there was no filing made in our system. So it's our fault.
Yes, sir.
It's a two-pronged issue. The first issue is because the statute that talks about the statute of limitations only talks should have filed into our system. We were on notice from the date it was due, and we had 1 year to file a complaint.
And there's no contrary case law in that.
There's affirmative case law to that.
Yeah.
Ethics Commission case law. The second prong, and this is where this case becomes a little bit of a unicorn, is typically speaking, if we had found out a year and a half, we could have filed a notice of inspection for campaign records, which you would be required to keep for 3 years.
Yeah, but can't you get those records directly from the bank?
What bank?
Yeah,
There's no requirement under the law to tell us where the bank is located.
that was something we added around.
He's been out of the legislature for 3 years, so he no longer has a duty to maintain bank records.
But does he have a duty to respond to interrogatories or requests for information? What if you recover the documents, and the documents indicated there was another violation of the Campaign Finance Act other than failure to file that now? We would have 1 year, right, to pursue that. So there could be other violations that occurred other than the failure to file.
Correct, and the reason this case is a unicorn is because we're outside that 3-year window to do the notice of inspection and to have a subpoena issue in order to get those bank records.
We have filed the notice to inspect the campaign records.
required to preserve and being required to respond to inquiries about readily available information. Is that not right?
Correct, but unfortunately, the 3-year statute at this point has already passed.
Okay.
Well, that's the main reason.
Go ahead, sorry, I've got lights all over the place. I don't know who went first. Commissioner Watts?
So the 3-year statute to the duty to keep bank records. But I guess to the chairman's point, like, what other discovery tools do we have besides requesting someone's bank records?
We have a notice of inspection and subpoena power. That is the only discovery tools we have. We do not have the ability to interrogatories, requests for admissions, none of the normal civil practice discovery tools. We don't have them.
Did you ask his lawyer what the bank is? Okay.
We tried. So, and I even went back through the old CCDRs to figure out if maybe they put fees on there, so I could see where the fees to the bank were, to figure out where
It doesn't, there's not a legal prohibition on it, but then we run also into a problem that an account holder has the ability to file an objection stating that we have no legal basis to seek the records, and then the subpoena gets quashed in federal.
Well, the legal basis to seek the records is that he had cash on hand in 2015, which you said was around 600. You said was around 600,000, and he didn't file a CCDR in 2019.
But it would be a frivolous subpoena because we would have no reason to believe that bank was a specific bank records.
Okay, well, I appreciate your integrity. I'm trying to find a way to figure this out.
Hold on. All right, Commissioner Watts has the floor right now. So Commissioner Watts is asking questions, and Commissioner Watts is going to direct the questions.
we've said a zero balance in a CCDR is a termination, or you file the termination paperwork in which you have a zero balance of cash on hand.
Okay, so have we asked his attorney? So why not file a CCDR?
Then I believe the statute of limitations would be open for us to go.
It's not terminated if they haven't filed a termination or a zero CCDR. You just said that. So just because someone says it's terminated, that doesn't mean it's terminated by the right way through the commission. So that's my point, I don't understand. You have to keep.
Mr. Wagner, yes, this is Doug Chalmers. May I be heard on a point, sir?
You can, but first let's finish this, and then you'll have an opportunity to respond.
A point of order, sir. If in fact we're going to be having a hearing today and discussing these issues rather than simply ratifying the administrative dismissal, I'm going to move to recuse Mr. Thompson on the ground that he did some work, campaign compliance work for my client. I was not anticipating we would be having an extensive discussion talking about legal issues, but if we're going to be going that route, respectfully move that Mr. Thompson recuse himself from the discussion.
Thank you, Mr. Chalmers, and I think that is a fair point. I'll let Mr. Thompson, the chairman does have the ability under the rules to require a recusal. I'm not going to do that. I believe Mr. Thompson, Commissioner Thompson, will do what he believes is right. He feels as though he cannot impartially act or decide this. Then I will let him so decide.
Well, a couple points. I didn't know we were voting on anything. I thought we were just having a conversation about what the authority of. So if this becomes a preliminary case, or if we're going to have that, but the chairman of the ability, office says they do not have the ability to ask for a commission member's recusal. So if we can answer that question first, but I did no work for Mr. Balfour, because I was never paid to do any work, and right now we're just having a conversation.
Well, the commission did adopt a rule which says that the chairman does have the authority. I believe that rule conflicts with the Attorney General's opinion, and that's the reason why I've never really exercised it. But to keep us on topic, what's before the commission today is whether we ratify the administrative dismissal. Is that right? And if we choose not to ratify it, what is it?
You would have to affirmatively reopen the case.
Okay.
There would have to be a motion that carries to reopen the case.
So, Mr. Chairman?
Yeah, just go ahead, Mr. Chalmers.
No, that was me.
Oh, sorry.
So the reason that I'm more than happy to direct my question to Mr. Chalmers, but the reason that I'm having this discussion and asking these questions is that I want to, well, one, I want some answers, and two, if this case can be reopened and discovery can be resumed in an appropriate way, filing anything with the commission, that hasn't been done, right?
Correct. There
Right.
has been determination.
And is that required to terminate your obligation to file with the commission?
So what we're running into with this is if they file a termination, say they go back and file this termination for, I guess the last filing date was 12/31 for the 12/31/2015 CCDR. If you file it for January 1st, 2016, that's when the campaign terminated for SMO.
Which you discover there's a violation of the Campaign Finance Act, you have 1 year to file a complaint. It sounds to me like there's
The argument is that account termination. You have 1 year from that date that they should have filed to punish them. We have no way to disprove that the campaign did not terminate in 16. We can't say, well, because it was open in 15, therefore it goes on ad infinitum. And we're kind of in that catch-22 because we can't get bank records. We have no way to force opposing counsel and his client to give us the bank records because of the statute of limitations.
So is it the staff's position that there is not a recurring violation of the act by failing to file either the termination or CCDR with at some point? Because at every year, to me, there seems to be a violation of this. Someone just telling you that something has been terminated without saying where the money went. The 600, it would, okay, answer this. Would the CCDR that they would have filed was $0 cash on hand, told you where the $600,000 went?
Yes.
Okay. But every year, you have to file one of these things. Or at recurring points through the year, you have to file these things.
It'd be the December 31st every year.
So, as of December 31st, 2019, one has not been filed.
Correct, and take your position to its conclusion, which we agree that there are knock-on effects. If you didn't file 17, you got to file 18, you got to file 19. If we allege you didn't file those three, the defense that is raised is correct. We didn't have to file, should have filed 16. We didn't file 16. Now the burden shifts back to us to prove that they had money after that and have to keep filing. It's a burden shifting problem. We can't.
It's a continuing violation problem. I mean, to me, I don't, the logic is a little, I just incorrect to me. If you have an affirmative obligation to pay your taxes, if every year I have to pay my taxes, if I decide in 2016 I'm not going to pay my taxes, that doesn't get me off the hook from not paying my taxes in 2017, 2018, 2019. It is a continuing violation. And at the point at which it's remedied, the statute of limitations will be reactivated because you necessarily will find violations. The logic here to me is incorrect. Not only is it incorrect, but it directly violates the public policy. And the reason why this whole situation doesn't feel right to me is because it's not right. All right, Commissioner Barlow.
I just want to make sure I understood the point that Mr. Lane made earlier. Did I hear you say that they have an affirmative obligation to file a notice of termination?
Correct. They have to file by law a notice of termination or a zeroed out December 31st report for each year in which they carry forward campaign contributions after they leave office.
And neither of those was done.
Correct.
So why can't we assume that the campaign is not over?
Because when we discuss and bring up those, let's just say we charge them right now within the statute of limitations for not filing December 31, 2019 CCDR. And we say in 15 you had money, and we believe, for whatever reason, upon information and belief, you had money for 16, 17, 18, and 19. The defense comes back to us and says, no, we terminated our account. We did it in 16 because we got rid of all of our money in 15.
But have they done it?
We don't know. How do we prove it? That's the thing.
Right, because like when we were talking about Mr. Baker, we can't prove it negative, right?
Exactly. It's not that we don't get me wrong. We don't like this outcome. We think it sucks.
Who has the ultimate determination on whether reasonable grounds to believe that the Campaign Finance Act has been violated?
The commission does, but as far as
what is the commission saying right now?
Completely hear you. But here's one thing to consider. Every time we've taken this to Fulton County Superior Court, who would enforce our subpoenas, it has been decided adversely against us.
But haven't we made the determinations on reasonable grounds without subpoenas being responded to in the past?
Negative inference, yes, sir.
Okay, so you don't necessarily have to have a response to the subpoena to determine whether reasonable grounds to believe. Is that?
The only distinction I would make is that it has to be a lawfully enforceable subpoena in order for you to do negative inference. If it is a subpoena that is unenforceable, you can't take a negative inference from it.
Commissioner Watts.
Just a question about your comment on subpoenas. Are you talking about, you said every time we brought an issue about subpoenas in front of the Superior Court, we lost. Are you talking about with respect to this case?
With respect to this issue, not so much this case, particularly.
The issue being the statute of limitations?
The 1 year performance statute, yes, sir.
And that, hold on, and that being the specific issue that someone has an obligation to file a CCDR with $0 cash on hand or a termination notice?
It's with campaign, the termination statement that we're using as a term of art. It's a campaign contribution disclosure report. It's the December 31 campaign contribution disclosure report. We just call it a final report and termination statement to turn it off.
And the Superior Court has said each time we've done that, which is how many times we brought it?
Twice.
And the Superior Court has said each time that one year has passed from their first failure to file, that there is no subsequent violation if they don't file the CCDR, termination CCDR, my term of art, okay, the next December 31st?
We haven't gone that far. You'd like for us to try?
Well, I want to hear everybody else, but I mean, my next question is going to be, did you ever appeal it? So I think you know my feelings on the issue. You did not?
Did not.
Okay.
All right, correct. Commissioner Cranville.
I've got two questions that are sort of different than exactly what we've been talking about, but it's two things that I want to make sure that I get an understanding of. You mentioned it a minute ago. I'm really curious about this whole, 1 year issue, putting the burden on us to know within 1 year that someone has not filed. All right. Do we have a mechanism in place now to remedy that? I thought that I heard you mention some kind of internal flag that should pop up or something.
The current system is supposed to do an internal flag to let us know that there have been non-filed. Unfortunately, that system has not functioned well for the past several years.
Well, here's my question, and I don't wanna cut you off, sure, but beyond this one, how are we gonna make sure this doesn't happen again? How are we gonna make sure that we know?
We have a brand new system coming online soon, which will hopefully solve that problem.
All right, yeah. Thank you very much.
There are two remedies to this issue. The first is, Mr. Lane's correct, January 1 of 2021, we will roll live a new e-filing account. Y'all heard me ramble about this for a year and a half, and then this is what I'm talking about when I say the current system is deficient in a number of ways. The new system will auto-flag that fact for us. The second remedy is that we are going to have legislation that fixes this blind spot and extends the statute of limitations for failures to file to mirror that of everything else that is filed. So those are the two. I'm not answering all the questions. I can answer those two questions. Those are the two remedies to the issue.
All right, I have one very specific question. And that is, if you fail to file your CCDR indicating you've zeroed out your balance, what authority exists to suggest that is not a violation of the Campaign Finance Act?
The way the law is written, you have to be able to show that the candidate or campaign had money in order to continue filing CCDRs. It doesn't read that you shall file a report until you terminate. It says you shall file a report on December 31 every year that you maintain a balance for that.
Okay, second question. Do you have to indicate to the commission that you've terminated your campaign finance account?
Yes, you do, on that last report showing you disposed of your money in that calendar year.
If you fail to indicate to the commission that you zeroed out and canceled your account, is that a violation of the act?
For that one report, yes.
Did either of those happen in this case? So you notified them that they didn't file it. But my question is, did they indicate to the commission that their account had $0 when they were required to do that? Did that happen?
Let me answer this question.
So it's yes or no?
We filed additional allegations that they failed to file end-of-year reports in 16, 17, 18, and 19. The response was the statute of limitations is run for everything but 19. That's the only one you have jurisdiction of left. We filed a notice of records inspection, and the response to Mr. Chalmers is no records exist, and they have not been required to be maintained under the statute of limitations for 9 months.
But that's not answering. So my question is, do you have an obligation to indicate we have $0 in our account? Yes?
Yes.
Did they indicate there's $0 in the account?
No, but then on our notice of additional allegations, then it just becomes a late case.
Well, it also reinvigorates the statute of limitations. I mean, I cannot agree to administrative dismissal of this case. I mean, and I welcome the commissioner's other thoughts. I fully appreciate the fact that you guys have spent a lot of time and effort, and I totally understand that. I'm not prosecuting this case. If I was prosecuting this case, I would think about a number of different ways to consider it. And if it comes before the commission and we ultimately determine there's no reasonable grounds, there's no basis. Commissioner Barnum.
Mr. Chairman, do we need to hear from Mr.
Yes.
Chalmers? I know
Yes.
he's been, because I want to give him an opportunity. I'm
Yeah,
probably going to land exactly where the chairman is, but I think we should hear from Mr.
no, I agree. And I'm sorry for my frustration on this. It's not you guys, you know, but if you've got $650,000 in an account.
Listen,
You got a campaign.
and we'll let Mr. Chalmers speak in a moment, but I'm not happy about this. We brought this AD probably 9 months after Mr. Chalmers moved for it. I don't know how we figure this out. Let's say the commission reopens it. I'm all ears, but I don't know how I obtain any evidence to figure out where the bank records are. So there's a reason we finally, signed the AD. I finally signed the AD. I don't know where to go from here, and I don't know how to get there.
I understand. Well, let's hear from Mr. Chalmers. Go ahead, whenever you're ready. Can you hear us okay?
Yes, sir. Can you hear me, Mr. Chairman?
We can, whenever you're ready.
Okay. Thank you all for letting me speak. I appreciate the opportunity. A couple of things. First off, I think we need to focus on the procedural issues and where we're standing in this case. The only allegation that's been made in this case was an allegation of a non-filing. There's a lot of questions being made now about monies and where it went. None of that is in this case. This case is a case about a non-filing of disclosure reports and had an obligation to file those disclosure reports. The case began with a third-party complaint filed by Mr. Perry. Mr. Perry misstated the law badly, asserted we had to file reports in June of various years. We addressed that. The commission staff then added its own allegations about disclosure reports, and we responded accordingly. A couple of things on the law. Chairman Evans read the statute 9328, which is the 1-year statute of limitations, but didn't read the entire statute. The chairman mentioned that it's a discovery rule and said all actions shall be commenced within 1 year from the time the defendant's liability thereto is discovered, and then he stopped. The next clause says, or by reasonable diligence could have been discovered. When a person does not file a disclosure report with the Ethics Commission, that is patently obvious from the Ethics Commission's filing system. The last time our client filed a report was nearly 5 years ago. He was voted out of office more than 6 years ago after having been falsely accused of various criminal violations that went to trial. He ended up becoming acquitted on every single one of those charges, but it cost him the election back in 2014. And the last time a disclosure report was filed was in January of 2016. We're coming up on 5 years from that time period. The Campaign Finance Act has a statute of limitations that applies to candidates. It is 3 years for violations that are contained in disclosure reports filed with the Commission. But because of case law decided both by the Superior Courts and by this Commission, any gaps in the statute are covered by 9328, which is a 1-year statute of limitations. As I said before, that statute says that to the extent that a violation could have been discovered through the exercise of reasonable diligence, then the 1 year starts to run at that time. To the extent there were questions about Mr. Balfour's non-filing of disclosure reports, or the dissolution of his campaign committee, or these funds, the Commission could have discovered by reasonable diligence 5 years ago what happened to them by engaging in the actions it is attempting to take now. In addition, we've been discussing just now whether or not there was an ongoing obligation to file the disclosure reports. Under the law, a termination statement is to be filed. It's not an ongoing obligation. It's to be filed within 10 days of the dissolution of a campaign or a committee. The dissolution of a campaign or a committee is not specified or defined, but it's my understanding Mr. Balfour's committee has not been in operation for a number of years. Under 9328, the deadline to go after him for a violation for not filing a termination statement expired. And in addition, on the question Commissioner Watts posed about whether or not there was an obligation to file a 2019 disclosure report, the filing obligation applies upon having excess contributions from such campaign. Commissioner Watts and Chairman Evans asked the staff if we have been asked whether or not those funds exist. I have responded, well, let me be clear, no, we have not been asked that question directly, but I have answered that there are in fact no campaign records for a complete and accurate answer to that question. Mr. Lane is also entirely accurate that if the Commission were to attempt to try and sidestep the statute of limitations and investigate that issue, there are in fact no campaign records upon which to make that determination. I can't give the commission a complete and accurate answer to that question given the passage of time and the absence of records at this point. And that is all we have said in our response, and happy to pass it back to you, Mr. Chairman. That's all I have.
All right, Mr. Chalmers, thank you. Commissioner Cranfield?
Mr. Chalmers, it's good to hear from you, as always. I have a quick question for you, if you don't mind. In your response, this was the second question I've been waiting to ask for quite some time now, but in response to the notice of inspection that was sent, was your response that there are no records, or do you just cite the 3 years and say that we're not required to preserve the records for 3 years, for more than 3 years? Mr. Chalmers? You may be muted.
Sorry, I accidentally muted myself when the chairman started to speak.
That's okay.
I'm pulling up the response. My understanding is that the campaign no longer has any campaign records, and we also are not required to maintain those records either.
Yeah, well, I see where the statute decided to that says you're not required to. My question went to whether the records actually existed or not, because I think there may be the response to the notice of inspection is that, and I just want to make sure that I'm very clear on this, that this particular campaign now is not in possession of any of these records. There are none that exist.
That is my understanding. There's no more campaign financial records remaining, in my understanding.
Okay.
Commissioner Watts?
Yes, so, Mr. Chalmers, you said, I think, just confirm for me or correct me, a termination statement is required within 10 days of dissolution of the campaign or committee. Is that right?
Yes, sir, that's the law.
I'm sorry, I missed that. Say it one more time.
Yes, sir, I agree with that, what the law says.
Okay, all right. And then, did you ever file and so the informer statute covered. At that point, would you suggest that the campaign staff reach out after some time of not receiving a CC?
I don't mean to be critical of anybody. Of course, I'm talking about the previous staff that was in place back at that time. That there would be a determination made and a question posed about whether or not the obligation still exists. When 5 years go by, time period in which the campaign is required to maintain tenancy, when he's been a private citizen for 5 years now, it is, in my view, too late to start posing these questions and then suggesting we should still have campaign records to answer those questions.
Okay. So, I think 2019 CCDR, December 31st, 2019, you said that's required when there are excess funds.
Contribution from such campaign.
And that means that the campaign account is not zeroed out, right?
I think that's a fair assessment.
Okay. So, is the reason that a 2019 CCDR was not filed on December 31st no campaign funds remaining?
My understanding is that there are no campaign funds in the campaign account, there are no campaign records, and therefore it's not possible to file a disclosure report.
It's not possible to file a disclosure report. Is that right? I heard not possible. But my concern is that it wasn't filed. So the 2019 CCDR showing a $0 cash on hand balance wasn't filed. You're right, it also wasn't filed in 16, 17, and 18. And then also that wasn't filed was a dissolution of campaign or committee termination statement. And so how is the commission staff supposed to know with reasonable diligence that campaign funds do not exist in a campaign account if a CCDR with a $0 cash on hand balance or a termination statement isn't filed? Excess contribution remaining as
Correct me if I'm wrong, but I believe the requirement for Mr. Balfour
the obligation to maintain those records.
And I guess I'm going back one step. The campaign, is it terminated without the CCDR or the $0 cash on hand balance or a termination statement that it has ended?
Secretary Mike.
Yeah, so Mr. Chalmers and I might not 100% agree on that, and that may be because factually we don't know when the account was emptied. If the account was emptied in the fall of 2017 after his to maintain that it's late.
All right, I'm gonna make a motion, we reopen the case. To me, it's one of two things. I understand the argument that whenever someone's put on reason, you determined by virtue of the failure to file a CCDR, that can potentially tribute the statute. The reality here is this campaign had the obligation to file a termination statement. At that point, the campaign would have been terminated, and simultaneously therewith, they would have filed a CCDR with a $0 amount statement. That did not happen. I understand the staff is going to have potential difficulty getting the documents, commissioners to determine whether there's sufficient evidence or reasonable grounds to believe the Campaign Finance Act has been violated. But I believe that's an exercise that should go forward, and the commission should be able to make that determination. So I'll make the motion that we reopen the matter of Donald Balfour, 2018-0098. Okay, we have a motion, we have a second. Any discussion?
Mr. Chairman, may I get a ruling on my motion to recuse Mr. Thompson before you take that vote?
Absolutely, Mr. Chalmers. And it's not a ruling, but it's up to Commissioner Thompson whether he wants to recuse or not.
For the sake of this, I will.
Okay. Commissioner Thompson has indicated he will recuse. So we've got a motion, we've got a second. Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Hearing none, the motion carries 4-0 with Commissioner Thompson recused. All right, so that will conclude our administrative dismissals. We're going to take a 5-minute recess, and then we will get back for rules for consideration. We will recommence, and then Mr. Lane, whenever you're ready.
Commissioners, what we've brought before the commission today is a request to repeal Rule 189-3-.03 of the Commission's Consolidated Rules and Regulations. That rule is governing what is called the reporting of deferred expenditures. And of course, you have the rule as it's presently written contained in your packet. But basically, what it's saying is that certain campaigns, and I'm frozen. What the rule does is it requires campaigns to report certain transactions using accrual accounting bases, no matter what kind of accounting basis that the committee is using. In any business entity operation, there are two types of accounting. You have accrual accounting and you have cash basis accounting. Now, accrual accounting is just simply to ask for them. Now, and the transaction types that we're looking to get rid of, aside from the deferred expense rule, is the third party deferred payment, payment on deferred expense, and then credit received on deferred expense. And just as a FYI for the commissioners, the vast majority of campaigns use cash basis accounting. They do not use accrual accounting. So the biggest problem we have with the current rule and its iteration is that it's requiring all of these campaigns that are using cash basis accounting to also do transactions on accrual basis. So you're inflating or deflating the cash balance artificially because you have candidates that are required by this rule to report, I received signs on September 25th, and I didn't get the invoice until October on my October report when I actually write the check. Now, in truth, nobody's following this rule, or at least it's so small that most people aren't following. An example of how accrual accounting revenue, which is revenue that's recognized at this moment, and then I would log in reconciliation later $50 from Mr. Famu. Accrued expense is an expense that's recognized right now, and then later in reconciliation, we actually write the check and pay. Deferred expense, which we actually do the opposite under our accounting rules, which we shouldn't. Deferred expense is cash paid, and then you later record the expense. What we've currently got right now is we're calling deferred expenditure is actually accrued expense. So it's causing the few accountants that are doing accrual accounting to get really confused and they're not reporting things correctly. So that's one reason we're asking for the rule to be repealed. There is absolutely no basis in accounting principles to require this deferred expenditure to be captured. Currently, the Act allows all campaigns to either do cash basis or accrual basis. The choice is theirs. Now, if the commission wants to pick one, that's perfectly fine. But you'll find that the only reason to do accrual accounting is because it smooths out the peaks and valleys of a transaction. So it gives a business a more honest assessment of the ups and downs of their income statement. Whereas for smaller businesses and campaigns, you see huge peaks and valleys because they'll get this huge cash infusion at the beginning and then they spend all their money at the end. So it looks like something falling off a cliff. The reason cash basis is done for most of our campaigns is they're not that big. The second reason being they don't have a need to flatten out their income and expense statement curve, because they all know they're going to get a huge glut of money up front and they're going to spend it all at the back. And generally it's easier because with accrual accounting, not only do you do the accounting on the front end, but you have 2 reconciliation periods that are done afterwards to make sure that your accrued accounting matches what your actual bank statements show. And no one's hiring compliance staffers to do the necessary reconciliation for that to be done. And that's why you're seeing a simple cash basis of, I've got a check, I log it, I wrote a check, I logged it, we're done. So we're just simply asking for 2 reasons, is to simplify the accounting for individuals so that they can do the cash basis that they're all doing anyway. And the second, probably more important reason is that our new campaign finance system will not support the deferred expenditure reporting.
Okay, Secretary Monty?
And I'll just emphasize the latter, which is that the system isn't equipped to do this, and to code in and build out the enhancements would cost a lot of money I don't have in the budget. So that's my concern. Yeah.
Now, is there anybody against this, and what would their arguments be if they were against it?
I can't think of a good one.
Okay. Commissioners, any questions? All right. So, anyone want to make a motion, or?
I'll move we accept the recommendation to repeal Rule 189-3-103.
All right, I'll second that. So we've got a motion and a second. Any discussion, comments, questions? I'll wait another minute. Commissioner Watts is gonna pop up. I better go while he still has it. All right, hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, it passes 5-0, and now we need to get Mr. Chalmers on. And who will be handling this? Secretary Motti, Mr. Lane.
And Mr. Chalmers.
Who would, Mr. Chalmers or Mr. Lane, who would you propose go first? Mr. Chalmers requested the opinion. Mr. Lane, you wrote the opinion.
I think it would be wise to have Mr. Chalmers go first since he posed the question.
I think that's fair. Mr. Chalmers, if you could talk about your request and then any thoughts you have on the proposed advisory opinion, that'd be great. And you may be muted. Mr. Chalmers, can you hear us? Mr. Chalmers, we can't hear you.
I think that might be us, because I can see it fine.
Can you hear me now, Mr. Chairman?
We can. Did you hear what I said earlier? I just want to make sure you heard me.
Yes, sir, I heard you offer me to go first, and I appreciate that. If that's the commission's preference, I'm happy to do that.
Yep, please do. We're ready when you are.
Thank you, sir. The basis of this advisory opinion is to get clarification on the rules governing using campaign expenses to pay for lodging. The request was framed for a legislator who lives outside of Atlanta and would have to rent lodging in Atlanta in order to attend the legislative session. As everybody knows, that is done as a matter of course. The Campaign Finance Act specifically says that one of the permissible, ordinary, and necessary uses of campaign funds is for lodging. lodging for campaign and official purposes has always been acceptable. So for example, if you rent a hotel to go to a campaign event, you rent an apartment to go to the legislative session or to attend political events in Atlanta, you may use campaign funds for that purpose. The question that is being posed here is whether or not campaign funds may be used for that purpose if the real property itself is owned by the candidate or the candidate's spouse or by a business entity that they own. So for example, the hypothetical involves a legislator who lives outside Atlanta. They have a piece of rental property in Atlanta. They would rent that property out to third persons if they were not using it themselves. And the question becomes, may they use campaign funds, or may the legislator use campaign funds for that legislator to stay in Atlanta during the legislative session and pay the monies to the entity that is owned by the candidate and her family? The advisory opinion concludes that the answer is no. We have provided some comments on August 12th and August 18th, which should be in your packet, and I won't repeat them in detail. What I would just do is highlight a couple of points. It has been consistent throughout the Campaign Finance Commission's practice to allow candidates to use campaign funds to pay the candidate or their family for fair market value provided to a campaign. So the principle which is mentioned in the advisory opinion, which is that any transfer of funds from a campaign account to a candidate's account is a violation of the Act, is way overbroad and is inaccurate. For example, if a candidate uses their own personal car to travel to and from campaign or official events, campaign funds may be used to reimburse that candidate for mileage. That is a transfer of campaign funds to the personal account of the candidate. Same thing if the candidate were to provide a computer of their own or office supplies or materials to the campaign, and the campaign were to pay and reimburse the candidate for that, that is entirely permissible. In previous years, this issue popped up in another advisory opinion dealing with commercial aircraft. And the commercial aircraft advisory opinion is discussed in this current advisory opinion, but I'm going to respectfully submit that it's been misapplied. The basic principle that was set out in that advisory opinion on aircraft is that candidates may use campaign funds, and this is a direct quote, I'll quote, "The Commission finds that a candidate is allowed to use campaign funds or expenditures for use of aircraft for campaign purposes under circumstances where the candidate or the candidate's spouse owns an interest in the airplane." So the Commission has already previously held that campaign funds may go to the candidate or to the candidate's spouse if they own an aircraft and provide that for campaign use or official use. The basic principle that's applied here is a simple one: paying for fair market value received. Campaign funds may be used when fair market value is received from the candidate. Campaign funds may be used to pay that candidate back. And the advisory opinion says that that's inconsistent by adopting an overly broad standard that campaign funds may never go to the candidate. If that is the standard, then campaign funds may not be used to reimburse for mileage, for other travel, for office supplies, for computers, or anything else of value that a candidate provides to the campaign. The one last thing I will mention before turning it over to Mr. Lane is that there is, in fact, a consent order that was entered by the Commission a number of years back. It was the 2001 0115 case in the matter of Terry Coleman. My understanding from Mr. Lane is it took the staff a while, but they did a good job and found that old order and were kind enough to provide it to me. And that order is inconsistent in a couple of important respects. The first paragraph basically says that while lodging is a legitimate campaign expense, and this, if you're looking for the language, this is on page 1 of my August 18th letter to the Commission. I'm reading the first indented paragraph there. Lodging is a legitimate campaign expense. The payment of expenses associated with a candidate or public officer's personal assets are not authorized expenditures of campaign funds. So they basically said you may not use campaign funds for lodging if you own the lodging. And the very next paragraph, they took the exact opposite position from a theoretical perspective. They listed a variety of payments to the respondent's personal office account for office expenses. The expenses were expenses associated with a campaign office housed within the candidate's personal office building. And it basically concluded those were legal because there's no indication that the transactions were not conducted at arm's length. In other words, in one paragraph, they applied the fair market value standard, and the other one they did not, simply because it was lodging. So I would respectfully submit to you, in addition, one last point, that this is a net zero for both the candidate and the campaign. If in fact the legislator comes to Atlanta and does not use their own property, they're going to have to use campaign funds to purchase another hotel or another apartment and pay rent there. So the campaign would be out either way that month. In addition, the candidate is not gaining anything because if the candidate can rent out that property to third parties, they'll get the rental income just the same as they would if they rented out the property to their campaign. So this is not a case of personal enrichment any more than is any other case where campaign funds are used to pay a candidate or their family members for fair market value that is provided to a campaign for campaign or official purposes. And that's all I have, Mr. Chairman.
All right. Thank you, Mr. Chalmers. And Mr. Lane, please explain to us your logic on the AO, and if you could also address the points Mr. Chalmers made. That'd be helpful.
Thank you, Mr. Chairman, and I promise not to be as inconsistent as the 2001 consent order. In drafting this advisory opinion, we kept the advice narrowly tailored just to the question presented by Mr. Chalmers. We have not done the parade of horribles that has been discussed, in which we're saying that you cannot use campaign funds for the provision of fair market services and value. For example, there have been instances where a campaign will hire a spouse who does public relations work, and they are paid fair market value for that public relations work, or they're in the business of doing campaign fundraising, and they're paid to do that campaign fundraising. We've always found that to be an ordinary and necessary expense. The fact that the family members relate to the candidate, there's nothing in the Campaign Finance Act that prohibits that. Additionally, Commissioners, what this Commission has done, at least since 2014, is you've always kind of adopted a but-for test to determine whether an expense was an ordinary and necessary campaign expense. And this came about when the Commission looked at a number of Federal Elections Commission advisory opinions, which, granted, the Federal Elections Commission doesn't control what we do. But one of their good examples of how to apply the but-for test was in the case of Senator Murkowski, the elder, not the younger, in which he asked the Commission, is it an ordinary and necessary expense for me to pay to move my family from Alaska to Washington, D.C.? And the FEC said yes, because but for the fact you were elected as a senator, you wouldn't be moving to D.C., you wouldn't have incurred these expenses approved. He then said, oh, but I'm not going to be drawing a salary, and I need to pay for food. Can I use the campaign funds for that? And the FEC said no, because you would be paying for those food expenses irrespective of whether you won your election or lost. You're going to have to eat every day anyway. So no, you may not use those expenses. So in drafting this advisory opinion, we have clearly stated that our advice is only as to the payment of lodging expenses. And just to be clear, we are saying that candidates can pay rent for lodging expenses provided they don't own the property in question. So there was a big concern that we're saying you couldn't have legislative housing expenses. We're not saying that. Legislative housing expenses are ordinary necessary campaign expenses, provided you live outside the metro county area. And what our advisory opinion says is that a candidate may not use campaign contributions to pay for rent or lodging expenses in real property that is owned in whole or in part by the legislator, public officer, candidate for public office, spouse of the same, or a corporate entity that is owned in whole or in part by the same. As such, transfer of campaign funds is tantamount to a conversion of campaign funds into personal assets, which is prohibited by Code Section 21.533C. And as the commission knows, 21533C is as close as our act comes to our personal use prohibition, and it says campaign contributions shall never become the assets of the candidate. We go on to say in the answer, with respect to the use of campaign funds for the payment of rent or lodging in real property that is owned by other family members, not including spouses, of the public officer, for example, children, in-laws, or corporate entities owned by the same, the commission advises that such payments may be permitted by the act as ordinary necessary expenses, which are not subsequently converted to a public officer or candidate's personal asset. So in the question presented by Mr. Chalmers, the candidate and her spouse, because my understanding is that this candidate or this official, the apartment condo is owned by the spouse, by themselves. It's not jointly titled. And what we're saying in that is that it's converting the assets because they're going to own this condo and pay the mortgage payment and the expenses associated therewith, whether she's staying in it or not. So the fact that she's a public official and having to come here, she fails the but-for test because they're going to be paying for this condo no matter what. She's not incurring the expense simply because she's coming to town. Additionally, there's been discussions between staff and Mr. Chalmers about, well, it's only in the husband's name. And we discounted that argument, and we explained in the advisory opinion. That doesn't work because in Georgia, a married couple, title on property is irrelevant unless you were claiming that the property is separate property that was prior brought into the marriage or inherited and brought into the marriage, because the spouse has the right upon divorce or death to make an equitable claim into that amount of property. And that's one reason why we have rejected that argument. Now that argument would be very good if, I'm just going to change the facts a little bit. Say this candidate and the spouse have 2 adult children, and they create an LLC, and the 2 adult children have over 50% control of the condo, and then the candidate and spouse have the minority share. That would be lawful under the act because the legal entity would control the ownership of the property, so it would not be an asset of the candidate and her spouse. And that's consistent with what I call the stand-ball line of cases that this commission has adopted before, discussing legal corporate entities, what their ownership structures like, who actually owns the asset, how much you need to have for it to be controlling and an alter ego of the candidate. So if you apply those standards, which is if you're a minority owner in the corporation owns it, it's not going to violate 21.533C. Because it's a corporate entity, you're not converting it to your personal asset because you have to go through other people to get your shares paid out. Additionally, with respect to the advisory opinions with the aircraft, and I know this is something Mr. Chalmers and I have disputed probably at length, you'll notice that the original request that came in about the aircraft ownership did so very broadly. It said, please advise us on aircraft ownership. And can we use those funds to pay for the flights that are outside of our ownership structure? The commission, in its subsequent advisory opinion, limited its advice and really limited it to the extent of a shared aircraft ownership model, not someone who just owns their own airplane outright. And so it's more akin to like a NetJets or a Delta private jet arrangement where you have purchased a lease for all intents and purposes, and you're entitled to like 12 flight hours. After you have used up your 12 flight hours that you prepaid for, you're charged a market rate by the jet operator for your forward base operating expenses, for your fuel, your crew services, all of that. So that's a fair market value, but more importantly, those fractional ownership interest in airplanes, you're not getting equity out of that. You can't turn around and sell it out to, for example, if Mr. Evans has an account with NetJets, you can't sell it to Mr. Amati. It's unassignable. It belongs to Mr. Evans. So that's one reason why the commission, in its advisory opinions, limited it. It didn't just say to everyone who owns an aircraft, yes, please feel free to use your funds. It was for fractional ownership interests only. So that's the distinction I'm showing with that advisory opinion. There was no financial benefit inuring to the candidate. Whereas in this situation, it does. They may not have tenants, they may never rent it out to tenants, who's to say, but every payment they make goes towards a payment that they would normally have to make anyway, irrespective of the fact she's an elected official. Additionally, every payment pays down the mortgage if there is one, or it goes straight into their bank account, which is a conversion to personal asset, and there's no fair market benefit service, and that's really kind of where we've drawn the distinction. It's not that you're giving like a good, it's you're giving a service with like the fundraising, the personal relations, the public relations. That's where we've said the service, you're giving a service good for value, and that's how they're getting paid. So that's the distinction we've made. That's why we've tried to limit it, and that's the logic behind our rationale.
What if you're renting a house in Atlanta?
That's fine.
Okay.
But if you're coming from Savannah,
Kind of like the tuxedo we took.
exactly. So like if you're living in Savannah, and
That's
you
my
need to come
complaint
from-
for the year right there.
Yeah, but exactly, if you're from Savannah and you need to rent a house for lodging during the session, perfectly legal. This AO does not change that.
As long as you don't.
Correct.
All right, Commissioner Watt.
So, a couple questions, just looking at the conclusion here, the second paragraph. You said for rent or lodging expenses for real properties owned by other family, specific facts on whether or not it's legal.
Yes, sir.
So, in a scenario where I own
No?
property, but put it in my daughter's name, and my daughter's 4, she's clearly not paying for that property, you know, would that be a factual scenario where you would say it's going into my personal assets because I'm paying for that property no matter what, she's not paying for it?
Correct, unless the property was owned in an irrevocable trust that named the child as the beneficiary.
Thank
I
you.
think that's the only way you could do it for a minor.
Okay, that was just out of curiosity, I was trying to understand where you're getting at there.
I should probably add like sui juris children.
Say that?
I should probably add like sui juris children.
Sure.
Instead of just children. Make it apparent they need to be of age and of legal age for consent, not a minor.
So, also, I think Mr. Chalmers, and he'll correct me, I know if I'm wrong, but I think he made a comment about like pens. So, and you know, other campaign expenses that you would make for things like that. So what if you buy pens with your campaign account, you lose the campaign, I mean, that's a personal asset now.
Okay. We're required to liquidate them and dispose of them with the cash, or to donate to charity. For example, you could donate pens to your local charity, the school. The school needs pens. Or you sell them, I don't know what the market is for used pens, or unused pens, whatever, but then you dispose of the cash. The example we always use is the campaign computer, because it's the one we see the most often. You have a campaign, they go out, they buy a new Apple laptop, they lose their race. What do you do with the Apple laptop? You can't just take it home. You have to pay the campaign fair market value for the used Apple laptop. So I'm just going to say it's $600 after a year from an original $1,000 purchase price. Now you can keep the computer because you bought it from the campaign, and the campaign gets rid of the money as the act restricts its ability to get rid of it. The commission had this case with a consent order of one of the mayoral candidates, Rogi Kamenachi. He had the mistake where he went and bought a campaign drone for $800 so he could do his own campaign social video, and then his campaign stopped and he kept an $800 drone. He subsequently bought the drone from the campaign and then donated the money accordingly. So we have addressed it before.
Who defines fair market value on the situation with the drone or the pens or the computer?
Well, Mr. Kamenachi, he purchased it at the exact same price that his campaign purchased it for. So we didn't have a dispute. I don't necessarily think that was the correct value, but I wasn't going to argue with him.
Have we ever had those before? This is so far afield of your AO now, I'm just asking out of curiosity.
I don't think we've ever had someone who has done a transaction that didn't pass the smell test. The one that sticks out of my mind the most was, I'm going to pick on Mr. Oxendine. His campaign would always buy 2 cars from like CarMax, and then he would drive the wheels off of them, and then he would, at the end of the campaign, sell it back to CarMax in order to get the money and then dispose of the money. But we always maintained it wasn't for us to determine fair market value and use of it, because he wasn't getting a benefit out of it. You know, if CarMax cheated him, $100 on the trading value, it is what it is. We have, to answer your question, I can't think of one where like someone told me the Apple computer was $1.
Right.
Yeah, I haven't seen that.
Okay, thanks.
Commissioner Cranville?
I'll be very brief, but I don't really think that question was all that far afield from the AO, because I think one of Mr. Chalmers' arguments, if I heard it correctly, was that it's more like a no harm, no foul kind of situation, as long as you're renting it to yourself for fair market value. I guess my question for you, and if Mr. Chalmers wants to answer, that's fine, but wouldn't that put the commission in the position of having to determine what a condominium's fair market value is? And is that a position or something that we really want to do?
Commissioner, may I address that?
Oh, yeah.
That has been the practice for decades. And basically what the advice that has been given to candidates and to public officials is you have to come up with an appropriate fair market value when you pay lodging for an apartment during the session anyway. And the reason is if you pay something more than fair market value, you've improperly used campaign funds for a purpose that's not ordinary and necessary. And if you pay less than fair market value, the person providing you the lodging is now given an in-kind contribution. So what has been done, as the staff has advised over the years, that you use basically square footage rates that are comparable in the neighborhood to determine fair market value. Just like when you have a mileage rate provided by the IRS, that's the standard that everybody should use. If you've got a square footage rate in the neighborhood, that's what you use. So I don't think that the concern about getting the commission involved in fair market value calculations is really the issue. I also think that it's important to note that the distinctions that Mr. Lane drew in discussing the draft advisory opinion do not make any, I don't want to say they don't make any sense, but they're not legally valid distinctions. The AO says that a transfer of campaign funds is tantamount to a conversion of campaign funds into personal assets. So what's the legal distinction there? That is an extremely broad opinion, and while the advisory opinion may be drafted narrowly towards one set of circumstances, as all you all who are lawyers on the commission know, when you establish a principle, it is going to be applied in other cases. So what's the legal distinction? Why would it be okay to pay for the use of a personal plane for campaign purposes or official purposes, or pay for a personal car for campaign or official purposes, but not lodging? Robert's answer focused on the but-for test and the fact that the legislator owns the property anyway. Well, the legislator owns the car anyway. The legislator owns the airplane anyway. Mr. Lane also focused on the question of, well, the legislator is going to use this money to pay their mortgage, and so that they're therefore going to get a financial benefit. That's the wrong part of the transaction on which to focus. We're not focused on what the legislator does with the money after they get paid for providing fair market value. It's whether they may be paid for providing fair market value. The person whose car has been reimbursed for mileage may use those funds to pay off their car payments. The person whose office may be used for campaign purposes and has been reimbursed by the campaign, which this commission found is permissible, may very well have a mortgage on their office property. That's the irrelevant part to look at. And the other thing I would like to mention very briefly is that Mr. Lane is focused on the wrong portion of the airline advisory opinion. He mentions that the reason that the commission got into that level of detail about the airplane use was because they wanted to make sure there was no financial benefit for the candidate. That's not really correct. The advisory opinion on the airlines got into that discussion so that they could say, so they were addressing, quote, or providing, quote, the following guidelines for reporting and disclosure of such expenditures. Mr. Lane has confused the issue of reporting and the proper amount with permissibility. What the advisory opinion on airlines specifically said was, taking into account the provisions cited above, etc., the commission finds that a candidate is allowed to use campaign funds for expenditures for use of aircraft for campaign purposes, and this is important because there are two parts. Number one, under circumstances, and part two, addressing how to do the reporting when we were involved in an aircraft.
If those two cases or scenarios came up, are you going to prohibit it?
No, and here's why. We've moved away from requiring candidates from disclosing their use of their own personal property for like campaign functions. For example, John Doe throws a campaign party where he brings 10 people into his private home and he's...
Not the private home, the corporation.
I'm getting there. I'm just giving you the example of what we've done. I'm going to hit each one.
Okay.
So you've got the private home. John Doe brings in the contributors to his private home. It used to be that there was a requirement by prior administrations, and I don't remember which ones, that you had to figure out the square footage of your dining room, and that was a contribution, self-funded contribution to your campaign. We don't require that anymore. As far as your example, the printing company, I think, for example, if it is a doing business as, and the candidate owns the printing company, and it's not a separate legal corporation, then it's just a self-funded contribution. The sky's the limit. You can donate as much as you want to yourself. If you want to spend $1 million on your campaign because it's a doing business as, a sole proprietorship, knock yourself out. Who are we to say you can't do it? And we've actually had people, Miss Stacey Evans, I want to pick on her, donated almost $1 million to her campaign. She didn't get it repaid. Now, was that a good use of money? Who's to say? I'm not going to say it. Now, let's change the facts a little bit different in your printing company. Your printing company is a corporation. It is its own legal entity, therefore it's subject to contribution limits. You can give free campaign signs up to the maximum contribution limit because the company is separate and distinct legally under Georgia law from you. And that's what the line of scam law cases have said. And just by way of refresher, because I don't think any of the commissioners were on the commission when Stambaugh and his line of cases came through, that case said we have Mr. Stambaugh, and then there's Stambaugh Company 1, 2, and 3. And what the complaint said was that there was exceeding contribution limits because all 3 entities made maximum contributions to the sheriff down in Camden County. When you peel back the onion, Mr. Stambaugh, of course, made his maximum donation as a person. That's fine and legal. But then Stambaugh entities 1, 2, and 3, although they're called Stambaugh, whatever aviation, what have you, he was a minority interest holder in all 3 corporations. And the majority holders in all 3 corporations were different individuals. So the line of thinking by the commission was, since he was a minority interest and he could not control the actions of the company without having the majority shareholders and board voting to approve that, each corporation was a distinct legal entity not subject to common source limits. So all 4 entities could do maximum campaign contribution limits. That's the Stambaugh line of cases, and that's the
But that wasn't my question.
Yes, sir.
It wasn't my question if you're a minority owner of a printing company. My question is if I own a printing company, and it may be a corporation, which is a separate legal entity, subject to the limits, are you saying that if the same question was asked, I would be personally benefiting because I use my own printing company?
And forgive me, I may have been obtuse in the answer. It depends on how you own it. If you own it as a sole proprietorship, aka there's no corporate structure, it's just you. Rick Thompson printing, Rick Thompson doing business, you file your taxes under your own social security number, you can do as much as you want because it's the same as if I wrote a check out of my personal bank account to my campaign. There is no limit on how much money I can get.
But you'd be a corporation of one. You'd have an EIN number. You can be a corporation of one.
But I said sole proprietorship, that's not a corporation.
But I'm not saying so.
But I've also answered, if you are a corporation, it is a distinct legal entity separate from you. You are subject to maximum contribution limits.
So I cannot use
Correct.
a printing company.
Correct.
And I think this is a rabbit hole we should not be going down.
I'm sorry.
Who said that?
I apologize, Commissioner Thompson, I didn't mean to interrupt you, sir.
Mr. Chalmers, do you have a brief? And I don't know if that's possible with you, brief response to Mr. Thompson, Commissioner Thompson's question.
I'll have to check if I'm being paid by the hour for this one or not.
Good answer.
No, I think Commissioner Thompson's question is exactly right on, and I think Mr. Lane's answer underlies the problem here. Mr. Lane is talking about a payment by the campaign to a corporation owned by the candidate as if that is somehow a contribution, and basically saying that because the candidate could contribute back the other way an unlimited amount, that somehow that's okay to pay unlimited amount. That's not correct. That's not how that works. For expenditures, the question is whether or not it's an ordinary and necessary expenditure, meaning whether or not it is of the type that is usually done for campaign or official purposes. There is nothing in the act that says that you couldn't pay a printing company owned by the candidate for the fair market value of campaign mailings. And it's done all the time, federal and state law. The question is whether or not the campaign is just giving money away for nothing or whether it's receiving value in return. And if it's receiving value in return from the candidate or the candidate's family, both federal and state law allow campaign funds to be used for that purpose, regardless of the corporate structure of the entity providing the services.
Thank you. All right. we're gonna have to start wrapping it up, so let's be pointed and efficient here. Commissioner Barnum.
Yes, Mr. Chalmers, Eric Barnum here. I'd like you to address something for me, just so I can get an understanding of your position. So I hear all your examples, and on some level they make sense. I guess here's what I'm struggling with. Whether it's a printing company or a personal lodging, there is presumably some profit margin built into the fair market value, whether you are measuring by square foot or the cost of a flyer. Those situations to me are separate from, the cost, the mileage for a car. How do we get to the concern I have, and that a lot of people have, that when you allow candidates to rent from themselves or use their own printing company, how do you get to the concern about that candidate profiting off of the campaign? Because presumably, irrespective of what the square footage is, we can't control, we don't know to what extent the candidate has factored in, or there is a profit margin factored into the cost. I liken it to the emoluments clause, right? The president is not supposed to profit off of her or his position as president of the United States under the Constitution. How do we get to the idea that a candidate might be profiting off of their campaign?
I think it's an excellent question. It does go to the direct theoretical underpinnings of the issue. And I would tell you that I think you have to sort of look at it from two perspectives. One, the perspective of the campaign, the other from the perspective of the candidate. From the perspective of the campaign, is the campaign losing anything by virtue of doing this? The answer is no, because every company that they go to buy their printing supplies is going to have a built-in profit margin built into the setup of the price. So there's no net effect for the campaign as long as fair market value is being provided. And from the perspective of the candidate, probably a closer call, but the candidate will be ending up being able to use the printing company to sell to other persons as well. And I will tell you that I've never seen a case under federal or state campaign finance law where the question has gotten that analytical. I think as a practical matter, the regulatory agencies and the FEC have looked to the question of, is the price comparable to what is being provided elsewhere? And I'll give you another example of that, discounts. When they determine whether or not an entity or a corporation has provided, has given a contribution to a federal candidate by virtue of providing a discount, they look to the question of whether or not that discount is offered to everybody. Is it the same price that you would give to everybody as a discount generally available to the public? If so, and that's your standard business practice, then you can offer the same discount to a candidate without making a contribution. That is the extent to which I think that federal or state law gets into that question. I think it's a good one, but I don't know that you can parse it that finely, and I don't think anybody else has when they're determining whether or not campaign funds can be used to pay a candidate. It's just whether fair market value has been provided.
All right,
Secretary, if I can, just want to follow real quick. So, but Mr. Chalmers, let me just ask you this. As a matter of policy, what is your thought as to whether or not a candidate should personally profit from her or his campaign? And I'll ask you to just assume for purposes of my question that a candidate runs largely for the purpose of putting campaign funds or having a campaign patronize various businesses that they own, whether it's a printing press or an office building or whatever it might be, and the candidate uses, or as a candidate, all of the campaign expenditures then go to these various businesses or real property that the candidate owns, and the candidate profits from that. As a matter of policy, I'd like to hear your position on that.
Well, Commissioner Barnum, as is commonly the case, you've asked hypothetically designed to a very broad set of circumstances. I think they're good questions. I don't think it necessarily applies to this situation, and so I'm going to narrow my response to this situation. That hypothetical doesn't apply here. This is the payment of rent for fair market value of rent, where there is no profit margin of cost. It is a standard fair market value rent agreement. And I don't think that hypothetically you talked about using a printing business or a commercial business with a built-in profit margin would apply.
All right, Secretary Money.
I'll be brief, and I'll start by saying, obviously, I support the proposed AO, seeing as I signed off on it. Commissioner Barner brought up something, and Mr. Chalmers responded. I don't know that I agree with Mr. Chalmers. I don't know that there is a way for a campaign to rent from itself and one or the other not profit. If it's fair market value, then the excess is going to the owner. And if it's not fair market value, the campaign's getting it cheaper. The second point I would make, and Vice Commissioner Kreinbull pointed this out, and Commissioner Barnes did as well, in a mileage example, okay, you drove 42 miles when gas was $1.99 a gallon. Or there are commonly set corporate and governmental terms for wear and tear, 69 cents a mile. This is a situation where the candidate themselves would be declaring their own fair market value, and now commission and staff, and ultimately the board, are in the real estate business. And I don't think that's an appropriate place for us to be. I don't particularly want to be there. So those are just the 2 points I would make, the 2 distinctions I would make, and that's all I have.
Okay, Commissioner Cranville?
I had a follow-up to Commissioner Thompson's question about the corporation, the printing company, if it was corporation. I just want a clarification on your answer.
Yes, sir.
You indicated that you couldn't do that. Were you saying that you couldn't do it at all, or it's subject to the limits of a?
If it is a corporation, you can do it subject to limits.
Okay, so that's what I'm getting at, is that it's not something in that situation that would be barred by the reasoning of the AO.
Correct.
That would be barred under the limits that the corporation can contribute to the campaign.
Correct, to be barred by 21.541 maximum contribution.
Okay, all right.
And just real quick, I just want to clarify something. So, when Mr. Chalmers was answering my question, and I respect the fact that the hypothetical was too broad, but I heard him say toward the end there, in the real estate example, that the fair market value would be, that there wouldn't be any profit associated to that. And I just don't think that that's the reality of the real estate market. Everybody rents property, most business people, and there is a profit margin built in. I think it's a rare occasion when someone rents property at whatever it costs them to operate that property. I just don't think that that's a realistic, and he added that piece on the end that wasn't a part of the discussion before. I find that part a little bit difficult to accept, but reasonable minds can differ. And I respect your answer, Mr. Chalmers.
Thank you, Commissioner. Right back at you.
All right.
Where's my love, Doug?
All right, anything else? Okay. I think that there's a distinction between cars and airplanes, or houses and airplanes and cars. Houses are appreciating assets. Cars and airplanes are depreciating assets. So paying back, reimbursing for costs for cars and airplanes is different, because you're necessarily taking into consideration the wear and tear, which is going to result in depreciation. I think you have to be very careful to make sure that we're not ever suggesting that individuals can deepen their own pockets using campaign funds. And I agree with a number of the commissioners that there is profit built into fair market value. Otherwise, people wouldn't rent out their places because they would have a direct disincentive to do it. So with that, I would move that we adopt the AO as it's written. All right, we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed?
Aye.
Okay, carries 4-1 with the law in opposition, Commissioner Thompson. All right, so we got up motion disallowing lobbyist registration or renewal to individuals with unpaid fees, fines, or penalties. Secretary Monty, lead us off.
This is simply the annual motion we do every fall before the lobbyist season heats up in December, that the board moves and signs off on an order that says they have to pay off any outstanding fines and fees that they owe the commission before they can re-register. You all have done it every September or August that you've been on the board. I'm just asking you to do it again so we can collect those outstanding debt.
I'll go ahead and make a motion, another request for motion in order disallowing lobbyist registration or renewal to individuals with unpaid fees, fines, or penalties or unfiled reports be adopted. Second.
All right, got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 5-0, and then report of executive secretary.
So today has gotten late, which means this is going to be quick, and I know that makes Commissioner Watts happy, who's leaving as I speak. Every month, every meeting, by the way. I'll be real quick. Haley, our new press secretary, was introduced earlier. She's been with us very briefly. She's already really helping out. Haley is going to wear several hats. She's going to take over as our open records officer with media outlets, which is time consuming in itself. If you've noticed, we have new social media accounts that have gone up so that we can communicate to the public better what we're doing and how we're doing it. In fact, this is streaming live on our Facebook page. Haley will be likely after the new system goes live, but Haley will be overseeing the new website, public-facing website design, and she will be working with education on regularly providing FAQs to the public through our various outlets. So we want to welcome Haley to the team. The second item, we are working with the Secretary of State's office and entering an MOU for qualifying. There is an interesting blind spot where, and I'll give an example. We had a state rep during qualifying in 2020 complained that both their primary and general opponent had not registered with the commission, had not filed financial disclosure reports. And our system was unaware of that because they never registered with us to begin with. This MOU with the Secretary of State's office will dig into our new system, and the moment they register with the Secretary of State's office, it will port that information and create a candidate file with us. So that's something that we get a lot of complaints about. They're fair, but if they don't register with us, we have no way of knowing until we're going to be closing that issue off. And finally, the e-filing system is on track. We're working with them 2-3 days a week. Robert is taking 4 days a week at this point. Robert and Holly in our education department, Erwin at times, are regular meetings with them. I'm meeting with them in the sprints. So we're in good shape there, hoping to roll that live January 1, 2021.
Well, good deal. And thank you guys for your hard work preparing for today. I know it's a lot. It's a later meeting than I anticipated today. I thought the agenda looked a little light, but we did have a lot of substantively in-depth discussions. All right. Mr. Fuller, we're ready for you.
Thank you, Mr. 11.
I got you. There you go.
Thank you, Mr. Chair. Just the only thing to report, next Wednesday, September 30th, we're going to have an oral argument in the Georgia Government Transparency and Campaign Finance Commission versus New Georgia Project Action Fund case. And we're last on the calendar on September 30th, so it'll be via Zoom. So y'all can attend from the comfort of your own home if you'd like.
Okay. Christian, I think you and Joe have been working on a couple of our legislative candidates who we sent over to OSA, right? Y'all been working on resolutions there too.
The Sabrina McKenzie case, yes, we have been working on that. We did have, I don't know if this, I think this occurred since our last meeting, the meeting that we had with opposing counsel. We have tentatively reached a resolution on that case, and so I think it's just a matter of getting paperwork signed and getting it over here. So I've been assisting Joe. Joe's been assisting me. We've been working together on that matter to get that case closed.
I just wanted to point out that they're working on that side of the fence on closing some cases.
Sure.
So,
And the same thing with Ms. Norma Marie Merritt. I know Robert and I worked on that consent order as well, getting that taken care of. And so I had some direct contact with Ms. Merritt myself to bring that case to resolution. So.
Good, thank you. Okay, I'm gonna exercise my discretion and call the public comment up next. That way we can just have executive session and then adjourn. Do we have anyone here that wants to make the motion then that we enter executive session if I can, for personnel matters, if I can get a second? Good, we have a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 5-0, and then we'll just get the room rolled and then we'll get out of here.